Good
Hello.
evening.
All right, I will officially open the meeting. Oh, do we have Jess? Are we waiting on Jess or she can review later,
We'll
right?
review later. Yeah.
Okay. All right. Sorry, I had my remarks. There we are. Welcome to the April 21st, 2026 meeting of the Planning Board. First, we'll take a roll call to introduce board members and staff. Maureen Collins-White,
I here.
Phil Giordano,
I'm here.
Tim Halladina.
Here.
And we are also, oh, I'm Ellen Rawlings. I'm also here. We are also joined by Amanda Wolf, our housing and land use planner, Nora Loughnane, our director of community and economic development, and Charlotte Lynch from Westwood Media Center. This meeting is,
Will Mike be joining us?
oh, no, Mike was going to try. He's out of the country and was having some connectivity problems. So I'm
Okay,
not expecting him, but if he does pop in, we will acknowledge him then. Oh, and we are also
great.
joined by Jess Cole, our recording secretary. Hi, Jess. All right. This meeting is recorded by Westwood Media Center and broadcast live on local cable television Comcast Channel 6 and Verizon Channel 42. Meetings are also live on the Westwood Media Center's YouTube channel. If you are interested in joining the meeting via Zoom, you can find the login directions in the Planning Board meeting notice that is posted to the calendar section of the town's webpage at https://www.townhall.westwood.ma.us/. We will begin the meeting with only the board members and staff unmuted and on video. As the chair recognizes individuals to speak, we will unmute them. Board members may choose to mute themselves when they are not speaking in order to minimize background noise. For applications, the chair will first invite the applicant to address the board and give a presentation summarizing what is being requested. Board members receive the application materials prior to the meeting and will have reviewed them. Board members may ask questions during and following the presentation. Staff and outside experts will provide comments to the board. If the issue includes a public hearing, the board will then proceed to the public comment portion of the public hearing and will restate the instructions. In this remote meeting format, residents and guests may participate in several ways. Attendees should raise their hand and wait to be unmuted and recognized to speak over the Zoom meeting application or from a telephone dial-up. We will be able to hear you but not see you. Additionally, comments may be submitted by email or regular mail prior to the meeting. When we come to that part of the meeting, I will remind everyone of the process. Following the public comment portion, the board will deliberate and make a decision or continue the hearing to a specific future date. All remote meetings require that votes be taken by roll call. When a motion and second has been made, the chair will ask if there's any further discussion before proceeding to a roll call vote and will then restate the results of the vote. Okay, great. Nora, do we have any changes to our agenda this evening?
We have one. The second item, there'll be a request to continue it to your May 19th meeting. That is for the 2240 Everett Street project.
Okay, so when we get to that, we
When you
would
get
just,
to that, you'll just immediately continue it.
perfect. All right, thank you. And no other changes aside from that.
No.
All right, then we will start with our first agenda item, which is 260 Washington Street, and it is a public hearing, so I will read a portion of the public hearing notice. The Westwood Planning Board will hold a remote public hearing on Tuesday, April 21st, 2026 at 7 p.m. via Zoom regarding an incomplete application filed by Foresight Education LLC for consideration of a limited environmental impact and design review, LEIDR approval pursuant to Section 7.2 of the Westwood zoning bylaw for a change of use from an existing personal services facility to a childcare facility and for associated alterations to the site and structure. The applicant proposes to construct 6 classrooms for children ranging from infants to preschool aged and proposes to undertake various interior, exterior, and site alterations. The existing on-site parking does not conform to the requirements of the Planning Board's automobile parking design standards, and the applicant is not proposing any alterations to the existing on-site parking lot to bring it into conformance with those standards. As such, no on-site parking spaces are provided for the proposed childcare facility. Employee parking is proposed to be accommodated through a lease agreement for 8 to 15 off-site parking spaces on a separate Washington Street property located approximately 1,000 feet north of the subject property. The property is in the General Residence GR zoning district. Land affected, Assessor's Map 23, Lot 186. Property owner is Alpha Wonder LLC. All right. Do we have folks from the applicant team? Yes, it looks like we do. Fabulous. Welcome. Oh, you're muted, sir. We can't hear you.
There we are. Thank you.
Of course.
We took
Welcome.
the third click. Good evening. My name is David Hearn Jr., and I'm an attorney with the firm of Gellerman and Cabral at 30 Walpole Street in Norwood. I'm here this evening representing the applicant, Foresight Education LLC, which is the proposed tenant of the property at 260 Washington Street in Westwood. This, as you said, is in the GR zoning district, and what my client proposes is to conduct a childcare business at that location. That is a use that is allowed as of right. It is a Dover Amendment right type of use. And we're before you, as I understand it, for a limited environmental impact review. You mentioned in reading the notice that there is an issue about parking, and we certainly want to discuss that with you. We have two of the principals of the organization with us, Shang Wu and Yiting Wu, and they are sitting in on this, and they may be asked to answer some of the questions. I've been involved in this only for a brief time, although I've been following it within the office, but I was elected because everybody else, I heard the chair mentioning some people have the week off and some don't. Everybody in my office seems to have the week off but me. So I was elected. But in any event, this is we've filed with you, I think, a detailed description of the project. We have also, I believe, responded to the issues relating to the limited environmental impact review. I do want to note one error on our part. Our summary of the project, I think, referred to section 7.3. And I discovered that this morning in reviewing the bylaw and reviewing the file. And I think what happened is this case has been pending in our office, this matter, for some time. And when it began, we were dealing with section 7.3, but you made some amendments to the bylaw last year that changed the numbering of 7.3 to 7.2. So I apologize if there's confusion on that, but we are here now under what is 7.2, even if some of our materials refer to 7.3. So that was a clarification I wanted to make. The proposal here is to take the existing building, which has been on the site for a number of years, I think known as the Sally and Rocco Hair Salon, and to convert it to a child care facility with 6 classrooms. We would expect to have probably 60 children there on a daily basis. A staff of 8 on the premises during the time that children are there. Parking is an issue. Our client has arranged a lease of a portion of the St. Denis Church parking lot to provide parking for staff. A little bit of a walk away, but they've gone to the trouble and expense of doing that, and that is for staff. As far as parking for users or parents or guardians who maybe have children in the facility, the proposal and the plan here is to provide a few parking spaces. And there is a site plan that I believe my colleague Susan Benham sent over to the office earlier today, and apologize for the delay in getting that, but it's actually a sort of a preliminary plan, not signed yet by the engineer, that shows several parking spaces, including a handicap space, to the rear of the property. The rear of the property is accessed through the adjoining property, which is shown on that plan as Lot B, and has an address of 250-256 Washington Street. By way of history, back in the early 1960s, the owners of our property and the adjoining property were the same people. And when they conveyed out what is called Lot B on some of the plans and is the property 250-256, there it is, thank you, the property to the right on this, as we look at this, they reserved and created easement rights for both properties that allow our property to be accessed through the driveway that is on the, I would say, northerly end of the northerly side of 250-256 Washington Street to access the rear of 260 Washington Street, our property. And rights were given to both sides to be able to use, share in common the parking on that site. Our clients proposed to have their, as has been going on for 60 plus years, have the rear of the property access through that driveway, which is their right, have the parents or guardians who are dropping children off or picking them up, pull up to the area to the back right of the building. There's a note there, some steps there. And if the children are being dropped off, a staff member would come to the car, open the door, unbuckle the children or the child, bring the child into the building. The reverse, when in the afternoon, when children are being picked up, reverse would happen. A staff member, when a car pulls up, staff member would bring out the child that belongs with that car, get him or her into the car seat, buckled in, and the driver picking up the child or dropping off the child does not get out of the car. So the parking in the back really is not important to the operation. This is a form of a drop off and pickup that I've seen. In fact, I experienced it with grandchildren when they were at a daycare in Dover some years ago, and we'd drive in, pick them up, or drop them off. We never had to get out of the car. This allows a quick and safe drop off or pickup. It avoids situations in which children might run across a parking lot, as they're wont to do, often particularly young children. And it would allow the driver to come in, turn around in that open space that is there, and then go back out the way they came in. We think that that is a safer approach than people pulling in somewhere, dropping, getting out of the car, children running across the driveway, anxious to get to school or anxious to meet up with their parents after school. So that is the proposal. We have shown on this plan a handicap spot and 4 other parking spots. We also show the location of the dumpster up by the building so that that is out of the way of any line of traffic. And as I said before, all of the access to the back of number 250 and to the back of our property at number 260 is by the driveway that comes in from Washington Street. So as far as parking that would, I know, be required normally under the bylaw, we believe this is a case where that parking is unnecessary on the site. We've arranged for staff parking down the street, and we have set this up or proposed to set this up in a way that would eliminate the need during drop-off and pickup for a lot of parking spaces. Now, we realize there may be some situations in which a child might have to be picked up at a time other than the normal pickup time. A child might get sick and have to be picked up by a parent or guardian and brought home, or might have to leave for some other appointment. In that case, where there might be one child leaving at a time, the parking spaces are there where the parent or guardian could pull in and go to the door to pick up the child. But in the ordinary cases of dismissal, and dismissal times would be at different times. One group of students might be there from 8 o'clock to 3 o'clock. Some might be there from 9 to 4. Some might stay longer, as late as 6 p.m., but not all are going to be dismissed or arriving at the same times. There's a certain staggering here of how the students will arrive. And so there's a couple of parking spaces if needed in those rare occasions where somebody has to come out of the normal times, outside of the normal times to pick somebody up, or maybe to drop somebody off also if it's a late arrival. But otherwise, the normal approach will be come in, drop off, turn around in that open area because nobody will park in those, and go right back out to the street. That's the same driveway that's been used for many years. As I said, the The deed creating the easement goes back to, I think, 1962. And so I know that the owners of the adjoining property have expressed some concern about traffic and the width of the driveway, but the same thing happens now, that if somebody's going in and somebody's going out, they just have to make adjustments, whether they're going to a business located at number 250 or we're going to park in back of number 260. We think that this is a safe and appropriate use. And this is, as I said before, this is a Dover Amendment use. So it is a use that is allowed as a matter of right over and above what might normally be the limitations on uses in certain districts in this town or any town. And so we think also that the concern about parking is obviated, and actually the only reasonable way we can operate this business at this location is as we propose it, dropping kids off in a queue and leaving. And I think that the parking requirements otherwise would have the effect of rendering this property, would prevent the use of this property in what is a protected use. In terms of the concerns expressed by Mr. Zaka on behalf of the Petruzziello interests, I did receive this afternoon a copy of an email that he had sent in last week. And he agrees that there is a reciprocal right-of-way and easement over the two parking lots. That goes back to the deed that he referred to, the book and page, as I said, was 1962. He refers, however, to a phrase and in the third paragraph, paragraph number 1 of his note, it being understood that no changes shall be made to such common parking area by the grantors or grantees which would prevent such common usage. It's our position that nothing that we're doing prevents the common usage. We would like to restripe the lines in the parking lots, the parking spots rather, that are in back of number 260. And we think that the restriping would more closely reflect the dimensional requirements for parking spots in the town, particularly a handicap spot. And I would think that back in 1962, when this was all decided and the easement and reciprocal rights were created, I don't even know that handicap spots were required. But we want to be sure that we have provided a handicap spot if the need arises. We have drawn these to be as close as possible to your requirements. And we don't think the restriping of lots, of spots rather, does anything to interfere with or constitutes a change in the common parking area that would prevent the common usage. To now, though, the Petruzziello interests have not been willing to consent to that. I'm not sure they have to consent to it, looking at the deed, looking at the easement language, and looking at the reality of the situation. So we understand their concerns, but their concerns are based on a use that goes back over 60 years. And all we're doing is changing the type of use. And it is a use that will be a little bit busy in the morning, a little bit busy during dismissal times in the afternoon or the late afternoon, 6 o'clock or so. But during the day, it's not likely that there would be traffic coming and going from this site. It is by the nature of childcare and that work, which is in demand and very important in this day and age, you have hours of downtime as far as people coming and going. The work is going on inside the building with the children, and people are not coming and going. That's different from the building next door, which I understand has different commercial uses as well as people living there. They could come and go all day long. And when this was a hairdresser salon, I suspect there were cars probably coming and going as people had appointments all day long and well into even into the evening and 6 days a week anyway. So we think that this plan that we have responds to the need for childcare in the area, responds to the concerns about safety and travel in and out of the site. We think it is a safer approach to dropping off kids for childcare than to have people park. And we do have the right to park, by the way, in number 250. We're not proposing to do that. We're proposing a line comes in, drops them off. It has worked well in other locations, and we think it would work well here. Happy to take any questions on this, and I think my clients who are present also would be happy to respond on any of this. Thank you, Madam Chair.
Thank you. Nora, I have one quick question before I ask for staff comments. My understanding was that the deed did specify that all parties need to agree to any changes to the striping. And if that's the case, does that mean unless the abutting property owner agrees, they can't redo any of the parking?
That is my understanding from having read and discussed the easement agreement with Susan Benham at a meeting in January 8th, I believe it was. I'd like to first point out that the plan that you have seen today was it's dated February 3rd, but it was only submitted this afternoon.
Right.
And so it was not reviewed, was not discussed. I can show you the plan that was discussed previously, and that was the application plan that was submitted. So just give me a second and I will call that one up. All right, this is the plan that was submitted with the application. And this plan shows, although they're not currently striped, they were proposed to be striped 10 spaces behind 260 Washington Street. Those are in the general locations of the 10 spaces that were used by the former commercial establishment there, Sally and Rocco's. And my understanding is that the easement agreement between 256 and 260 Washington Street allows for the use by either building and their tenants and their customers of the 10 spaces on 260 and the 10 spaces on 256. So the concern was how we would get to a point where we could have the type of drive around proposal that the applicants are looking for in an area where we were not able to restripe the parking lot or change to eliminate any of those 10 spaces that are used by both businesses without the consent of the adjacent landowner. So when we met in January, we asked the applicant and their attorney to go back and see if they could meet with the abutting property owner and work something out. So we had not heard. In fact, the last time I spoke to Susan, I think was probably about 2.5 weeks ago. And at that time, there was no other plan that had been approved or discussed. I think it was brought to the attention of the other property owner, but was not approved. So that must be the plan that was dated February 3rd that we're seeing tonight. So if we could go back to that plan, Amanda, had you called that one up?
Yes, 1 second.
Could you put that up again? So just a couple of things I want to point out on this plan, and I'll mention that it has not yet been reviewed by the building commissioner, though Mike Perkins is now on the call, so he can weigh in. It doesn't show that I can see the dimensions of these 4 parking spaces that are shown here. Are they there? I see the back up.
9 by 18.
It does say 9 by 18. Okay.
One of them is 9 by 22.
Okay.
And I can't read it right now, but underneath the handicap one, there is a dimension 9 by, I think it's 18.
Okay. Yeah, I can't see. Oh, I see it now. Yes, 9. It looks like they're all 9 by 18, including the strikeout area. So the presumption is that handicap space is a van accessible space, which would be required for a single handicap space on the property. Now I want to call your attention to this one up here, the parallel space that is properly sized, 9 feet by 22 feet. However, I'm not sure how a driver would actually get into that space because there's not an area for them to pull through. I think what they'd have to do is come in kind of angled along next to the dumpster enclosure and then back out the opposite of how they've come in. And I'm not sure where cars would turn around in this lot. There's no clear turnaround area. So the concerns that I would have is that it's reducing 10 spaces to either 4 or 5, depending on whether it's possible to access this parallel space, making your way around the dumpster in a safe manner. But there's no turnaround area. When we have dead-ended parking lots, we have to have a hammerhead turnaround area, and that is not provided here. So the concern that staff have prior to even reviewing this plan, and that the police department had to do with the way that cars will come into the site, access the spaces or drop-off area, and then turn around. And that's over and above the concerns with whether or not the applicant can actually make physical changes on the ground which eliminate any of the 10 shared parking spaces.
Madam Chair, I can respond to some of that, but I don't want to interrupt the flow if there are other comments by Ms. Loughnane or anybody else.
Yeah, I was going to see if there were any additional staff comments. I know Mike Perkins is here. I know I think we're all seeing this for the first time, which is frankly less than ideal. But Mike, if you're here and have any thoughts, if you don't, that's okay too, because I know this is the first
No, I would echo Nora's comments that there's not any real defined turnaround, drop off, staging area, or whatever it might be in that parallel parking spot. I feel like I'm decent at parallel parking, but I don't know if I can fit in there. I don't know. I would think, like Nora said, the hammerhead parking area, so to speak. I think that would eliminate one of those normal parking spaces and possibly the parallel parking spaces as well. But again, the turnaround / drop off area is kind of difficult to ascertain where that might be at this point. So again, I haven't done a full review. This is the first time I'm seeing it, but that would be my concern as well.
Thank you. I appreciate that input. Mr. Hearn, if you had comments in response before I open it up to board comments, that would be great. Thank you.
Thank you. A couple of things. I understand the concerns that we've just heard about where do you turn around? The fact of the matter is that we propose that nobody will be parked in any of those spaces. So the combination of the aisle, 24-foot aisle, and the parking spaces that are unoccupied is where somebody who pulls in roughly by the dumpster area and that walkway that goes to the steps into the building would drop off children and then loop around over around the area there, go forward, loop around in all that space that is available because nobody is going to be parking there, and then go back out to Washington Street. We show those to show that we can provide parking spaces for the rare occasions where somebody may come in, as I said, to pick up a child. But if somebody comes in to pick up a child at an off time for illness or some other reason, they're going to be pulling into one of these spaces, the others not being occupied. Our staff will not park there. We will not have other people parking there. There's really no occasion. We're showing, though, that we can provide a couple of spaces. Now,
sorry, I have a quick question. Yeah. We heard earlier that the parking agreement between the lots is reciprocal. Does that mean it goes both ways?
It does. So
then people who are not part of your establishment could park in those spaces if they exist, correct?
I suppose, and we could park in theirs if somebody was concerned about that. They've got, I think, 10 spaces there laid out on the plan.
My point is simply there's really no way to prevent people parking in the areas that you're proposing that cars turn around, is what I'm hearing. And that's what I'm trying to get some clarity on.
I don't think that the history bears out that the people at 250-256 have been parking in our area. Could they? Perhaps. But I think that the use, the times of day that this will be used and all that, this is going to be laid out so that children can be dropped off and go out again. Now, I do want to speak to the comments that were made about the easement rights and the fact that there is another plan that showed 10 spaces on it. That is not necessarily a plan of record, and this is not either. We realize this is presented to show you a layout that provides some spaces, but with the intention of keeping that area open so that people can drive in and drive out after dropping off children. We're certainly happy and would expect that you would need something signed by the engineer and stamped before it could be made part of the record. As far as the rights go, I think that a fair reading and is of the easement language is that that a right was granted for the common use of existing parking areas, not parking spaces. There is no mention in the deed that created the easement of parking spaces or number of parking spaces. What it was that, and I suspect that in 1962, when this was done, they probably weren't even marked as parking spaces. But the fact is that there are rights given to both parties to use the other's property, and it is not to specific spaces, nor is it to a particular number of spaces. It's to use parking areas. So I want to make that clear, and I think that is the way to look at it. And then the question is that changes shall, it being understood that no changes shall be made, and I'm reading from the deed, in such common parking areas by the grantors or grantees, the grantors being our predecessors, the grantees being the predecessors of the owner of the property next door. No changes shall be made in such common parking areas by the grantors or grantees which would prevent such common usage. Nothing we're doing prevents common usage. What it does is defines a couple of parking spots if we need them, but we don't even think we're going to need them. So that is the, I think that the deed has to be read in its plain language. No mention of parking spaces individually, no mention of number of parking spaces.
I understand. I think what this board is looking at, one, I understand you're saying this isn't necessarily the end result plan or the plan of record, but for this board to be able to evaluate your application, we have to look at what's in front of us. And we also don't just look at the deed, we look at our current bylaws under which there are certain numbers of parking spaces and proscribed by the proposed use. And you're correct, this is a Dover Amendment use, but parking and its impacts on abutters and traffic are one of the few purviews that we have even under Dover Amendment. So it is something that I think this board will consider. I do see some hands up. I see Mike Perkins. I'm going to start with Mike, and then I'm not sure whether Maureen or Phil went up next. But we'll start with Mike Perkins, and then Phil or Maureen can let me know who was next.
All right, thank you, Ellen. No, I would just say again, in my cursory review of the deed, and I'm not an attorney, my understanding or taking of that was that it was not necessarily granting essentially shared parking across the lots. It was if one party or one property was going to change their parking layout or use or whatever it may be, both parties needed to sign off on it. So I'm not sure exactly. Again, I'd have to cut through some of the legalese there to figure that part out. But the other part of it that I was just going to say was if there's going to be sufficient offsite parking for staff and or patrons, customers, students, whatever the term is, I would say on this plan, don't even show the parking spaces if you're not going to use them. If you're saying they're going to be used for drive-in, turn around, drop off, etc., show that as a striped cul-de-sac type, circular drop-off aisle, rather than saying we can stripe these, but nobody's going to use them because, again, if the neighboring lot does have access to those and can use them, what's to say all 5 of those spots aren't going to be blocked one day and we're going to have a difficult situation with parent drop off. I'm sympathetic to the need for the childcare and for the I guess, difficult position that the existing layout of the property has put the applicant in. But at the same time, if we're saying we're going to have 20 cars or 10 cars or whatever it may be going in there and turning around, I can foresee an issue on both of these properties at those times.
Thank you, Mike. Mike, Maureen, I'm sorry, Phil, Maureen. I'm not sure who had their hand up first.
I think Maureen was before me.
Thanks, Phil. All right, Maureen.
Now, I was going to make a comment about the joint parking like you did to Ellen, but I'm saying you said something, Mr. Hurt, about there being 60 families or 60 children that were going to be in this daycare.
That, we
And I know they stagger.
they will be staggered in their arrival and departure. Yeah.
Okay.
Yeah.
Now, I guess I just had, and the only entrance for the families to go in and out of is in the back. They won't have any access to the front. I'm just.
I think one of my clients might be able to answer that question, but the reason it's designed this way is to keep the drop-off area away from the busy traffic of Washington Street and in a quiet area in the back of the property. So less chance for accidents or the type of congestion that can create accidents or create injuries. So I don't know whether Ms. Wu or Mr. Wu might want to comment on that, but whether, entrances or access in the front of the building is contemplated. Yuting, do you want to speak to that, or
Yeah.
Chang?
The back entrance is only for the parents driving the car. If they are walking or use a commuter like transportation, they can use the front door.
No. I mean, we understand that there's a concern that patrons of our business not use the municipal lot, and I understand you would be concerned about having any long-term parking there and all that. But we've taken care to come up with a plan that avoids any use of the municipal lot across the street. In part, it avoids crossing the street too, which is important, I think, for safety. So if somebody, as Ms. Wu just said, somebody is walking, they can come in the front door, but otherwise the drop-offs would be in the back.
And was that it, Mr. Hearn?
Yeah, if there's another question, happy to take it.
Yeah, and I just have one question. Why do you have the dumpster there? Could you not maybe move it and make it maybe a little more accessible in the back?
Well, I think that the dumpster being there, as opposed to where it was shown on a prior plan, keeps it, leaves more space open for people turning around than maybe putting it in the back. Up there, because of the lay of the land and the way the building is, it's sort of more out of the way for traffic in our thinking. But we're open to, Mr. Perkins' comments about why even draw spaces. It's a good point. Maybe we paint on, it'd be better to paint on the ground arrows or markings to show where you go in, how you go out and all that. But we certainly would look at that. But that's our thinking on the dumpster. That gets it actually more out of the way than somewhere else.
Yeah, because I took a look at the back. There's a door right there where the rolling dumpster is, correct?
There's
the rolling dumpster. There's also a door.
And steps up into the steps to the building are there. So there's a little walkway. I can't point on this, but there's a little walkway.
Oh yeah, there's the door. Okay.
And then you go in there. Right. So the dumpster would be below that.
Thank you.
Thank you.
All right. I was jotting down a note. Was that at this time? Are you good, Maureen?
Yes, thank you.
No worries. I didn't want to move on to Phil if you. All right, Phil.
Yeah, I have some questions. And Mike articulated some of it with the striping and whatnot. It strikes me as the striping actually impedes the ability to have flow of traffic, and that to me is a major concern, because you have it appears to be such a tight spot that if you had one handicap park or if any of those spaces are striped and there is a car from the adjoining property, 250, 256, it's going to be very, very tough to be able to do that. And I actually, while we were talking, I reread the Dover Amendment, and our purview does include a reasonableness standard under the Dover Amendment. So I think that it is reasonable for us to be asking some of these questions. And then the third thing is, what about snow? What happens if there is, because we obviously just had a very challenging winter with substantial amounts of snow. Where is that going, and how is that going to be addressed?
I don't have a direct answer, but I think that there are areas referring to that parallel parking spot there next to the dumpster enclosure that might be a good place to dump snow when we're plowing the drive-in, drive-out area. There's also some area beyond the actual lined parking spaces, but within the property to the easterly side, the bottom part of this plan that we're looking at, where there could be some plowing there. So I think there are a couple of places where you could put the snow, but I can't say that, the definite plan on that. That's something we'd have to refine in order to keep the snow. And I suppose if it becomes too big a problem, it'd have to be taken out off the site. But I think there's room there to plow it near the trees and up in that parallel area that would be out of the way of our intended path of travel.
Now, I hear and understand your drop off, but that implicitly means there would never be like a holiday event or something like that, which is common in daycares, nursery schools, all those other kinds of things, whether it's around whatever the holiday may be, whether it's Halloween, Thanksgiving, Christmas, all the different things. Because then if parents are coming and attending, there's no place to put them. Would you agree with me that that would implicitly or explicitly need to be a condition of any approval?
There may be no place to put them on this site, but I think the question is for those occasions, and they're occasional situations, whether providing parking for the greatest use of a particular thing that may happen only a few times a year, if it even happens, even if we do it, is a good use of resources when there is some street parking, there is some municipal parking in the neighborhood, just as somebody might use municipal parking or street parking to go to any of the other businesses in the area. If that happened, I'll leave it to my clients if they want to comment on whether there would be plans for holiday gatherings or not. But I suppose that's an issue with almost any of the smaller daycare facilities located throughout the area. Where do you put the people if you have a big crowd show up on those rare occasions? I agree, we couldn't accommodate them on this site. We wouldn't expect to. I think we'd expect to maybe use the parking areas along the street if they're available, or municipal lot. These events, in my experience with young kids, you're there for maybe an hour, and then everybody, including the performers, have lost their attention span. It is something that could come up, but it could come up at any property that has even the events at our different schools are often result in people parking on the public way because the facilities are not designed to hold all those people all at once. So that would be it. It's not a perfect answer, not a perfect solution, but it is, I think, a realistic way of looking at it. That yeah, there might be occasions, but I'll leave it to my clients whether they have any comments on whether there would even be plans to have gatherings like that, or whether they be, sometimes some schools have them off campus. We've been to that. I've been to that also with some of my grandchildren's events. They have a particular play or something at a different location, not even at the school, because the school is often not set up to with large rooms and stages and all that stuff that we see for those types of things. So I don't know whether Yuting or Shang has a comment on it, but if they don't, that's fine too. I'm just trying to answer your Mr.
Yes,
Giordano.
yes, I agree with both of you. And just like David say, like if we have a special event, like we will definitely maybe like rent more space from our neighbor, just like our previous school did. Like if we have a big event, we will ask our neighbor, like, can we rent for 2 hours per this day? Or maybe we will find another location to have a bigger event.
Okay.
Uh,
I think
Actually, for right now, we don't have any plan to host any big event during the holiday. So I think if any event was had, so they will be scheduled during the no traffic day, like the Sunday or Saturday. So
Mhm. Okay, I tend to think, having had 4 children, but 1 hour is kind of short. I would think holiday events, if you did have them, would definitely be at least 2 hours. Can you give us some sense of the parking and travel that does occur at the Petruzziello property? I mean, what's the number of cars that are typically parking in there? Give us, because that's kind of something that is pretty important, just given this entire layout.
I do not know offhand. I don't know if my folks have observed parking there and whether it varies from one day to another.
I think like we've been there a couple of times. Like we already have this property for a year, and then every time we've been there, like there are no car in our parking lot.
Well,
So
not just your parking lot, because in some respects, the issue is also, entry and egress. I mean, coming in and out, because that, you have 60 children coming in, and then depending on where the parking is utilized on the 250, 256, you could have cars maneuvering around parked cars in order to do drop-offs. And that, if it's typically 1 or 2 cars, and that's typical, or if it's, basically mostly full, that's a different scenario. And that's something that I think that does weigh in here in some respects.
I think, Mr. Giordano, if I could, on that point, the easement requires that the parties keep the property, the traveling ways open, so that anybody using our property has an unfettered right to come in off the driveway that leads off of Washington Street and come along. And this plan shows that the Petruzziello property has marked spaces, 4 above, 6 below, and a wide aisle that is probably at least 24, comparing it with our plan, at least 24 feet wide for cars to come and go. So if they're using their spaces, if they are using their spaces, they still have to keep this open. And if they have overflow, I guess they've got to figure out what to do, whether they park on our property, if there's space available, or they go and find some parking somewhere else. But they're obligated to keep this open for us.
Or they have to put their snow somewhere also.
I'm sorry?
They also have to put their snow also, because that also has a significant tendency to narrow spaces and make the entry and egress it's just a function of a fact of what happens in the winter around here. So,
yeah, but these properties have had this common driveway and parking arrangement for over 60 years. So I think, and I'm not aware of problems that they've had. I've heard concerns expressed very recently, but over 60 years, we haven't heard of, I'm not aware of any problems that have occurred, whether it's snow or numbers of cars or anything like that. So I think time has told that this can work and does work. But again, we're trying to present something that is a reasonable use of the property, but for a protected use that necessarily involves crossing another property, but that right was created by the original owner or the then owner of both properties. And everybody who has bought number 250, 256 Washington Street has taken title knowing, or should if they were reading the deeds, that we have always had the right to cross that through that driveway and go across that property to access the back of our property. So again, snow comes, snow goes, and it is a concern. But I would suggest that the parties have probably learned to deal with that over the years without any major problems. I'm not aware of any problems. My clients are not aware of any particular problems. So
Respectfully, I understand what you're saying, but there have been a lot of changes to these properties over the last 5 to 10 years. The properties on either there's been significant changes to the uses and the structures themselves. And I've lived in this town a long time. I can tell you that the hair salon did not generate the kind of traffic that a 60 student childcare facility is likely to generate. So I think I understand what you're saying, but I also understand where my colleagues are coming from, is this is all things that we as a board need to consider realistically when we're evaluating the ask to give a waiver for on-site parking. It's not something that I think any of us take lightly. So I understand your point, but I don't know that I agree to say that it's worked great for 60 years, because a lot of things have changed in that time, including this would be a very large deviation from the type of use and traffic that we have seen generated by that property for the last 59 years. So I understand what you're saying. I just kind of want to level set that from my perspective. I do see some hands up. I know Tim has been waiting, and I saw Nora's hand up. I'm not sure if you two have a preference as to who goes first.
Let Tim go first.
Thank you.
Thanks, Nora. I'll be quick. I see a lot of issues with this, to be honest. First off, the width of the entryway. How wide is the width at the narrowest point?
which are you referring to?
At the nearest point of the entrance.
The entrance to our property, or the entrance from Washington Street?
The entrance that cars would be entering and exiting.
Entering our property.
Yes. From Washington Street. Yeah.
From Washington Street into.
That's an existing, let me see if I have it on the plan.
For context, is it narrower than the entry onto Washington Street for the property to on the other side of your building? Even if it's just a relative comparison, because I know that's already just extremely tight and there's increased volume there. But I'd like to know that width. That'd be helpful. And while you're looking that up, I guess I have 4 kids under 9. I've sent kids to 5 different daycares across several states. That I don't think the logistics that has been outlined of a drop-off circle, which there isn't really a circle here in the first place. I don't think it's as easy as discussed. These kids they're not elementary school, middle school. A lot of times these drop-offs require, they're infants. I assume I thought I read infant to pre-K. Drop-offs and pickups often require parking, attendants to help these kids get in and out of cars, walking in. I just logistically, this seems like a real issue with how you're going to route cars circularly around this back lot, while also having, I guess I'd be curious to know what the plan is for attendants or employees to support getting the children in and out of the cars. But that's going to add a lot of time. Cars backing up. I heard the mitigation tactic of trying to spread out, but again, these are really little kids that there's not like clearly defined. You can try to have clearly defined pickup times, but a lot of times there's other circumstances that come into play that can impact that. So I think I just see a lot of issues. Also, car size wise, you're probably skewing towards family vehicles, larger SUVs coming in and out of that tight space is a concern for me. Not having a loop to properly circle around, and then lastly, I see a lot of issues at that entry point on Washington Street, where it becomes 2 lanes down to 1 lane. And there's a lot of potential accidents or issues at that point when it merges from 2 lanes into 1 lane. And if I recall, I think this is right around that area. So I could see this being relatively problematic for cars exiting as well, taking left. And I understand that this has been in use this way for some time. But to get in front of that question, I don't think it's been in use in this time for these quantities at these hours. So I just see a lot of issues here, to be honest, and just wanted to put that all out there.
If I could respond on a couple of those points, Madam Chair, but I don't want to interrupt Mr. LEIDR. But I could respond to a couple of those while it's fresh, with your permission.
I'd like to go to Nora, and then we can come back to that.
All right.
Or actually Nora and Amanda, and then we'll come back to that. I like to get staff's input too, so thank you.
So I wanted to go back to the parking demand, the zoning bylaw parking requirements to start with. So the former use, Sally and Rocco's, I believe had a parking demand under the bylaw based on the square footage for the commercial establishments they had that allowed them to operate with 10 parking spaces. For a child care facility or a preschool, the parking requirement in the zoning bylaw is 1 space for every employee plus 2 spaces for every classroom. So if I heard correctly, and there are going to be at least 8 employees and 6 classrooms, that's a minimum parking requirement of 20 spaces. What's been shown to you on the plan that we just received today is a total of at most 5 parking spaces. And I would argue that there are really only 4 usable parking spaces there. So if you took those, even if you took the 5 parking spaces and then you added to it the parking spaces that are leased at the St. Denis property up the street, year 1 of the lease that was submitted to the town, which actually started on April 1st, 2026, allowed for 8 parking spaces. And then they had years 2 through 5, which allowed for 14 parking spaces. There's no mention of what happens after that 5th year. If you're granting an approval for a reduced parking, you need proof of parking for the duration of the business that requires that off-site parking. So that's the first question. The second question is how many spaces you need. If there's a minimum parking requirement of 20 spaces for this use, and there are at most 5 spaces on the lot and at most 14 spaces in the off-site parking area, we're starting at a deficit. We're already 1 space short. And the vast majority of the spaces, 14 of the 20 spaces required, are not shown on site. I don't believe the planning board has ever granted a waiver or a special permit in the case of a non-Dover amendment use for that level of reduction of parking requirements. Those are my first comments. Second had to do with the driveway width, where you enter the property at 256. The driveway ranges from 12.5 to 13 feet wide. I think at the narrowest, it may be even slightly less than 12.5 feet wide. In any event, 2 cars cannot pass in that driveway. So for the length of that driveway, you could only have 1 car coming in or 1 car going out. That means if someone is entering from Washington Street and does not have a view of the parking spaces that they're heading to, they don't know if there's a car coming in or coming out until they've started to head in. So that would give way to the need for a parking attendant standing at the street. In addition to the parking attendants that are helping children get out of the cars in the back of the school, you would need someone directing traffic at all times if there's anyone coming or going. Otherwise, you could end up with cars being stuck half in or half out, or attempting to back out of the driveway onto Washington Street, which I think would be an extremely dangerous condition. So I think at a minimum, you would need to have in a decision a need for a parking attendant. And then I have a couple of questions. We already discussed that there is no apparent turnaround in the area, so there would be use of the parking spaces to be used as a turnaround. That, I would argue, eliminates their ability to be used as parking spaces and goes further to the lack of parking. And then I have a question about the 60 children that would be arriving in the morning, how they would be staggered, how many would be coming in each quarter of an hour, keeping in mind that people are not always on time. And so you might be scheduled for the first or the second drop off, and you might actually fall in the area of the third drop off. So that would be one question, how that would be managed, how many would come per hour. And my other question is how many times are we seeing the pickup or drop off? My understanding is you have a drop off period in the morning, you have a pickup and drop off simultaneously or back to back in the afternoon, some students leaving, some other children coming in for
No.
aftercare, and then you have a final pickup at the end of the evening. So I think the board could use more information on how many students, how many cars would be expected to drop off, how many students at what particular times, and how many per quarter hour during the pickup or drop off times.
Happy to speak to any of that, Madam Chair, when appropriate.
Yes, I saw other staff members' hands disappeared, so I'm happy for you to address the questions.
Okay, thank you. In terms of the drop-offs, 2 drop-offs in the morning, around 8 o'clock and around 9 o'clock. 2 pickups in the afternoon, around 3 o'clock and 4 o'clock. A further drop-off, or pickup rather, around 6 o'clock for students that have remained beyond the 3 or 4 o'clock times. It's not that new people are coming in the afternoon. There are no new people coming in the afternoon. All of the pickups are of students who were there from 8 o'clock or 9 o'clock in the morning, and they're picked up at 3 or 4 or 6 if they're on the extended day arrangement. So I hope that clears that up. In terms of the width of the driveway, I just measured it with a scale ruler, and it's roughly 15 to 16 feet wide, measuring it against the 24-foot aisle that we show on our plan. I think it would be useful. It sounds like it would be useful to get an actual measurement there so that we can be positive on that, but I've been sitting here with my scale ruler and that's what I get for a width, but I'd rather have an engineer do it, and we could do that. On the question, going back to a prior comment, in terms of the method of dropping children off, I've seen this system work. I had grandchildren that went to a Precious Beginnings preschool in Dover, and we would do the drop off or pick up some days. And you pull in the property, you loop and wait by the gate, and a staff member comes out to get the child out of the car, unbuckle them, take them into the school area. And in the afternoon, when it's time to pick up, the kids are waiting with their staff members, and there are 8 staff members at all times on the site. And the children, as a car comes up to pick up one student, that student will be taken by the staff member out to the car and put in the car and buckled in. So there's no need for parents or others to get out of their cars. That's how it was done at Precious Beginnings for years, and for all I know, might still be. But it does work, and this is not something these folks have come up with by themselves. It has been used at other childcare places. We acknowledge that we don't meet the requirements of the parking on site, the normal parking requirements based on number of staff and number of classrooms. My clients have gone to the trouble of getting a lease of a portion of the St. Denis parking lot, a certain number of parking spaces, 8 to start, then going to 14, to be able to have staff park there. We don't propose to have anybody parking, and maybe it would be clearer if we just wiped out the drawings of the most of those lots there. I suppose if we need to keep a handicap lot, we could create that and not have it get in the way. But I think that while the town has some oversight, even with Dover Amendment cases, there are cases in which the courts have made clear that some of the requirements, if they have the effect of preventing the proposed protected use, those requirements may have to give way unless it can be shown that if we can show that they're not really advancing the particular interests that are intended by the provisions of the zoning bylaw. Major concern or interest we've heard mentioned, and I think would be encompassed within the zoning bylaws concerns, is the avoidance of accidents, safety risks, and what we're proposing is designed to reduce the chance of accidents caused by having cars navigating in and out of parking spots, caused by having children loose in a parking lot or running across a parking lot. This is all designed so that it's very well controlled when the children are coming and going. They're met by a staff person at the car. They are brought to the car at pickup by a staff person. They're not running loose. And that is a tried and true method of handling the arrival and dismissal of children from this type of operation. So I think that the concerns that the town may have about safety that would normally be tied into the number of parking spaces may have to bend to that. And I'm referring in particular to the Rogers versus Town of Norfolk, a 2000 case by the Supreme Judicial Court that is still good law and still cited. If the application of the requirement under the bylaw would significantly impede the use of the premises as a child care facility, while not substantially advancing a valid goal of the town zoning regulation, the provision might be considered unreasonable. I'm not saying you folks are unreasonable. I'm not saying that the concerns are not real concerns, but the question is, with the favor that is given to uses under Section 3 of Chapter 40A, sometimes the actual counting of spaces that would normally be required has to give way to whether there is an alternative approach that satisfies the concerns of avoiding overcrowding, of keeping things as safe as possible, reducing traffic congestion. We think this does it. But I also know from the comments that have been made tonight that there is probably some information that could be developed that may help on this. And that information is from my notes and some of the comments that have been made, might suggest that we give you a little more information about the number of children and how many at each drop-off time. Also, whether we can establish with it maybe an engineer or surveyor's measurement the width of the entry from Washington Street and the street into that driveway. And I'm familiar with the fact that the lanes do change somewhat along that stretch, near that stretch, and go down from 2 lanes right in the middle of Islington to 1. But we could get a measurement on that, and also perhaps show you a drawing that shows the proposed lanes and turning radius in that. And I apologize, we don't have that. This has been a project that we've been working on and trying to find the best way to handle it. The use of St. Denis parking lot on a rental arrangement is an example of my clients trying to respond to a particular need, the drop-off arrangement. But I think we could illustrate that a little bit better. And I would ask that the board consider continuing it so we can give you a plan signed by the engineer, stamped by the engineer, showing the measurements of that driveway, and also see if we can develop a little more information, historical information, because I can't say what's been going on out back there. I've had no occasion to be there in the Petruzziello property or ours, but also a clearer layout of where the cars would come in, where they would go out, how they would turn, and to show you that in a way that might help to assuage some of the concerns that you have. This is an important use, and I think that we should try to, we're happy to try to get you more information, and I would ask that it be continued to your next hearing so we can, assuming it's sometime in the next few weeks, I don't know your schedule, so we could get that information in through the staff and get it to you in plenty of time so that we can have a more detailed discussion of it.
So I actually have some comments, if I may.
Yep.
Few things. First of all, glad you mentioned Precious Beginnings. My daughter went there, so I'm very familiar with that parking lot. It is, you come in and you come out, it's a significantly larger lot than what is behind the property in question. And there's also on-site parking in addition to that turn in and turn out. So I agree, that works beautifully because it's got the room for it. I have concerns about, I'm not convinced, I'm just going to be completely clear here. I'm not convinced that you can do the kind of turnaround that you're asking for. And in fact, our comments from our police department and public safety officers stated the same thing, that they are concerned about whether or not that turn can be executed. So I understand you think that will be safer, and I think on paper it would be. But with some of the other concerns, since you have to cross through another parking lot, which yes, they can't prevent you, but it doesn't stop other people from coming in and out and using the parking spaces in there. I am concerned about whether or not, I don't know that I agree that a waiver of the on-site parking spaces would be more safe than parking cars and having to go in. I see nothing on this plan that shows that the turn's possible. I see nothing that shows that it's actually a safer option. So I have concerns about that. I know that is a heavy traffic area. Washington Street is busy, East Street is busy. So I don't think it's unreasonable for this board to be concerned about a potential backflow onto the street if there is a delay in getting people in and out. I don't think that's safe for anybody. As Nora said, I've been on this board for a while. I've also observed planning board hearings for a while, and I don't think I've ever seen the planning board, Dover Amendment or not, approve this significant reduction in on-site parking for many reasons. So that gives me pause as well. On top of the other reasons that I've stated, safety is a huge concern, and causing more backups and traffic and issues is also a huge concern. And I'm not sure that I agree with your assessment that waiving the parking and allowing for a turnaround that may not even be feasible is actually a safer option. So I have concerns there. And I know there was some talk about the municipal lots on a Sunday or something, and this is kind of tangential or even secondary or tertiary. That area is never not busy. So I don't particularly get jazzed about hearing any reliance on any kind of municipal spaces. That area already has traffic and parking issues in the public areas. So that is something I keep in mind as well, not just for events, but in general. I did see two of my colleagues have their hands up. So I think Maureen and then Phil.
You want to go first, Phil?
I'll just be quick because I'm reading paragraph 3 of section 3 of chapter 48, no zoning bylaw, and it goes on with respect to childcare facility, semicolon, provided, however, such land or structures may be subject to reasonable regulations. And it goes on regarding yard sizes, setbacks, open space, parking. I think reasonable regulation and reasonableness is very clear in the Dover Amendment. And the chair has been on the board a little bit longer than I, but I don't know Dover Amendment or not, that we are not reasonably concerned about this particular area. And I will echo my colleague Tim. I am concerned about the width of that entryway, where that is, particularly if there is no sight when somebody's driving a large SUV with 3 or 4 kids, or just family size, to be able to come in here. I think all the questions are really demonstrating, I think, this board's concern about some of the issues that are here, and I echo all those concerns. Otherwise, I've said my piece. Thank you.
Thank you, Phil. Maureen?
Yeah, I just have 2 comments. I'm just wondering also if there is a child with a disability, how is that child going to get in and out of the establishment? And also, obviously, there's not going to be any like playground facility or anything involved with this. It's just all indoor, correct?
Correct. That's right. Yeah.
So what is there a plan if there is a disabled child that's going to this?
We'll be in compliance with ADA requirements. Yiting, if you want to comment on that? If a child that required assistance.
I think we are still having disabled like parking there. So if a child like they need the space, we'll definitely have the space for them. And then I just want to circle back, like we do not have the outdoor play space, but we have an indoor one, and then we will use the the playground outside. And then also like our plan is like we will have staff like to make sure to monitor the circulation of vehicle going in and out. Like we like safety is definitely the priority for us too. So yeah, we will have my plan is like we will have like one staff like in the entrance, like stand on the entrance, and then one or two on the back entrance, and the one in the front door. So we will have the staff member to do that.
So I'm sorry, when you say use the playground, do you mean the playground up the street, the school street playground?
Yes.
Okay. Um,
Let me put my hand down.
I was just
on
gonna
that
say,
one.
Maureen, did you have
Yeah.
any other comments? I do see we have at least one comment in the queue. Sorry, I would love to open it up to public comment unless there are other board member or staff comments at this time.
The only comments I would make were having to do with the measurement of the driveway. So the measurement we provided was from an aerial photograph with a measuring tool attached. Certain to the accuracy of that to within an inch or two, but we would be happy to pull a tape measure across the pinch point of the driveway. But even if we were to stipulate that it's not 12 and a half to 13 feet wide, it's as wide as 15 feet, that would still not be sufficient for 2 cars to pass. So we still have that same problem that cars cannot be entering and exiting at the same time. So this would cause a queuing effect on the property, but more concerningly, it would cause a queuing effect off of the property on Washington Street in either direction for cars looking to come in. So if there are 2 drop-off times, 8 a.m. and 9 a.m., and 2 pickup times, 3 p.m. and 4 p.m., and then a late time after that, the presumption, at least for the 8 and 9 a.m., is that it could be half of the children will be dropped off at 8 and half at 9. If that's the case, you have 30 children being dropped off in an hour. I think it's more likely than not that there will be more than one car entering and more than one car exiting at a time. So I think that if you're looking for an engineered plan, that would need to show queuing, and it would need to show queuing on this property, on the adjacent property, and on Washington Street. Otherwise, I don't think it addresses the concerns.
Thank you, Nora.
We can provide that, Madam Chair.
You can provide, yes, sorry.
We can provide the details that Ms. Loughnane just mentioned.
Okay. All right, I would like to open it up to public comment. I see we have one in the Q&A. Just a reminder for any folks here who would like to offer public comment, you can either raise your hand and we can enable you to speak, or you can use the Q&A section of the Zoom app. Either way, we do need your full name and address for the record. And I can read the one comment we have. Fran Fusco, 20 Pine Lane. Is there no outdoor play space for the age-appropriate children to play? I think we did hear not on site. The intention is to use the school street playground. Is this proposed project only daycare, or is this a preschool / school as well? And how many cars / SUVs can be queued up in the driveway for drop-off without being on Washington Street?
Etain, can you describe the program in terms of, the question was daycare versus preschool?
Yeah, we are a bilingual school, so it will be like 0 to 5. It also like a daycare, but we will have a like Chinese English bilingual environment. So our name is a Sunsprout Bilingual School.
Thank you. And I don't know if there's any way to kind of address the question about cars and SUVs, maybe a ballpark, how many could be queued up on the property before they end up backing out to Washington Street? I don't know if.
I was going to ask, do we need a traffic study just on the queuing? Because the queuing seems like this could be an issue.
So for a
Nora?
Jumper Amendment property, you cannot request a traffic study, but the applicant can provide a traffic study if it's necessary to assure the board that there is a safe way into and out of the property without disturbing traffic.
Yeah, it's just at 8 a.m. That time is very, very busy, and that's my concern.
Thank you. While I give it a moment to see if there's any other public comment, just from my perspective, I think I heard there was talk of maybe a continuance. I would like to poll the board and see where people are at, because like I have serious concerns about granting a waiver on all the on-site parking, given that I have concerns about the proposed solution, because I actually think it might cause less safety than it provides. So I don't know what other people are thinking. I mean, but I think we should poll the board. If a continuance makes sense, I think that's a good idea. But if people are just not inclined to pursue this at all, then I think that's also appropriate. I don't want the applicant to continue with designs and whatnot if this board is not inclined to grant that waiver at all. Because even the design, Nora, correct me if I'm wrong, if we were to go the route of the turnaround, it would still require the parking waiver for that to be a solution, correct?
It absolutely would. And I have one other question that just came to mind. A question in our zoning bylaw of whether this is going to be considered a child care facility or an educational facility, because they do have slightly different parking requirements. So the child care facility is based on the number of classrooms, where an educational facility is based on the number of seats, where one seat is required for each participant in the educational facility. So that's one other question that I'd have. We need a definition of whether the proposal here is a child care facility or an educational facility.
And Nora, this may be a silly question, but who decides that? Would it be the applicant, or is it determined based on what the programming is? Is there a kind of a statewide determination there?
So it's determined by the building commissioner, Mike Perkins, based upon information that's provided by the applicant.
Okay.
So for instance, the difference would be if it's a child care facility, the parking count requirement would be 20 spaces, 8 for the employees, 12 for the 6 classrooms. If it's an educational facility, then I believe the parking increases to 23 spaces, because now it's one per employee plus 1 for every 4 seats.
Okay.
So where it was 12 associated with 6 classrooms, it would be 15 associated with 60 children.
Thank you.
Nor is there, what's the minimum that would be required for 2 cars entry and exit, minimum width in
20
that
feet.
point?
20 feet
I thought it
minimum.
was 18 for some reason, but 20,
So 2 cars, if they're not SUVs, can probably pass in an 18-foot space.
okay.
But we require a minimum passing of 10-foot lanes.
Okay. I just polling, I'm open to a continuance and but there's obviously a lot of issues that still require a lot of work.
Yeah, I'm with Phil. Steep. I think it's a steep hill to climb, and I think we haven't even talked about the concept of pedestrian risk too. There's sidewalks there. If there is a backup or a queue, that's a busy time for people walking to school. I think there's a lot here that we need to dig further into.
Thank you. Maureen.
I agree. I think it needs a little more work, a lot more work.
All right. Then it sounds like a continuance is in order. I think the board and staff has been very clear about what the concerns are. Again, I would need to see that it's feasible to actually do the kind of turnaround that you're suggesting on paper with measurements very clearly. And I still have concerns about granting that much of a waiver for on-site parking. But I think a continuance is what the majority of the board is interested in. Yes, Amanda.
One more thing I'll note to the applicant is when you design the turnaround, make sure that the accessible space isn't conflicting with that turnaround space. Because if the plan is for a student that has accessibility needs to park there, then that must be accounted for in the design.
Got it.
Thank you.
Okay.
Staff, is there anything else that we as a board should convey to the applicants to kind of maximize their ability to answer our questions? Or
I think the only other thing is the duration of the lease for off-site parking has to be coexistent with the duration of the use. So if the request here is for an approval for an ongoing use, you need an ongoing lease. So the lease right now is for 5 years. And one of those years has already begun. The other thing I would point out is that this application, if the board is willing to grant a waiver of the parking plan requirement, windows or doors, changes in material, different walk surfaces, dumpster enclosure details, all of the typical application items that the board needs have not been submitted with this application.
That actually raises another question for me, Nora, because you mentioned landscaping and dump sites. So this lot obviously hasn't been touched in quite some time. Would these changes then trigger compliance with our current bylaws?
They would. And there are, in addition to the parking requirements, there are screening requirements. Whenever a parking lot for more than 5 vehicles is brought into play, it's either existing or it's been altered, then those vehicles have to be screened from view from eye level on any residential property. So that would require additional screening requirements. In addition to landscape, you'd probably have to put up some solid fencing in areas where there is none.
Nora, if Mike found it to be educational as compared to daycare, would a reduction in seats make it more feasible for us to be able to consider the possibility of a waiver?
It would. So you have a couple of questions here. One, the use is a Dover Amendment use. The location is of concern. The parking is of concern. The size of the building and the number of people served by the building are within the board's purview. So if the parking is insufficient to meet the needs of a school for 60 students, then perhaps a school for less than 60 students would be appropriate.
So that might be a way where, especially given it's a Dover Amendment property and use, I should say, then that we could kind of meet a little bit more in the middle. That would, if that's reduced, it could alleviate some of our concerns, not all, but some.
So yes, so the size, the number of students that are there, the number of teachers, the number of classrooms can affect the number of parking spaces required. But I think the gating factor here is the drop-off program.
Right.
And that has to be solved first.
Okay. Those were just my questions.
So I'm going back to the other bylaw requirements. Given that space is tight there, are we likely then to be looking at additional waiver requests for screening?
Absolutely. Yes.
So there's going to be a pile of waivers from requirements.
Yes, there are screening requirements that require landscaping, 5-foot perimeter buffers of landscaping around the building, around the site, and solid screening from abutting residential properties. It doesn't look like the plan that we saw tonight has room to do most of that. I could be mistaken. As I said, we just received the plan, so it has not been reviewed.
But just to be,
it does show a fence, 6-foot fence along the back of the property.
There is an old fence there. I don't know that it is fully impervious, and it's along the back of the property and not along the sides, I don't believe.
I'd have to look at that. And again, this is a reason perhaps to continue it to a date that makes sense to give you the additional information that's been referred to. May I ask, Madam Chair, Ms. Loughnane mentioned a 2-step process, and parking is a big concern here, parking and circulation. Is it being suggested that we could do this in a two-step fashion of coming before you and with additional information that's related to the questions and concerns that have been raised tonight, to deal with the question of what waiver the board may be willing to give? And I hear you now on what you're saying, but focusing on the parking, and if we get over that hump, then we would come back with the specifics about the building renovations and landscaping and screening that requires a different type of plan with those details and the expense associated with that. With the board, and I don't know whether you've done that in the past, whether you consider giving relief on one part, and if the applicant gets that, then the applicant moves on and files a separate request for approval on the other aspects, the, as I say, landscaping, screening, and any building renovations that might come into play under your rules.
You could, but I just and I'm speaking just for myself, I'm just looking at the plan again. One of the abutters is a private home that will be impacted by this change and the increase in traffic. So I will personally be very interested in the screening and landscaping and not necessarily willing to just waive all that, particularly on the border with the private home. So I would encourage you to think about that as well, because that is something that we will consider and I will consider as well. So
Yeah.
that even if you get the parking, if you're going to need, it's looking at, like, given the space is limited, some of the parking requirements or to do that turnaround might necessitate not being able to meet some of the other requirements. So I would encourage you to at least familiarize yourself with what the bylaw says on the screening and the landscaping to understand what would be expected and how much or how little you think you could do to also meet the safety requirements and do the turnaround or parking. And that's just from my perspective, because I will be looking for those, particularly on the border with the private home.
And you're referring to the property at 3 Stratford Place.
Correct.
Yeah, I'm not suggesting we're looking for waivers on any of those points, but I understand you still review all those.
But you might have to be able to compromise on some of the parking issue. That's kind of what I'm saying, is at least I think you need to look at the whole picture to understand what other things you might need to ask for relief on to be able to do some of the things that might be necessary to even make the turnaround feasible. So I would just encourage you to kind of at least review it to understand what the next step would look like, because I would hate for you to find a way to make the turnaround work and then have me or the board say, well, now you don't have any room to provide relief to that abutter, and that's a problem. So I'm just trying to just give you the whole picture from my perspective.
And I appreciate that. And I think, no, I'm not suggesting that we would say, okay, if we got over the parking hump and that hump, then we're going to come in and ask for all kinds of waivers. But my understanding is you folks want to do a review anyway, where there's a change of use on a property that relates to the matters that Ms. Loughnane mentioned in terms of, and I'm looking for my notes on it now, but the screening, landscaping, those are important. We understand we would be, I want to put it this way. I'm not expecting we'd be looking for relief on those. We understand the need, and Madam Chair, you pointed out a particular concern with respect to the residential property directly in back. So I think our plan contemplates some screening on that, but we'll review it with our engineers and review the bylaw to see what the requirements are. The first thing, and I think the concern is, there's a fair expense involved with putting all that stuff together. If we can do this with if we can do this in a 2-step process, I think it saves. If it works out, fine, they do the step 2. If it doesn't work out, they haven't spent the money on stage 2, step number 2. So I appreciate that, but I hear you loud and clear on your concerns, and I'm sure others share that with respect to any abutting residential property. And you pointed out one in particular there. So thank you for that.
Sure. Nora, just to make sure I'm not missing anything, from staff perspective, is it possible to do something that would still leave room to meet some of the screening and buffer requirements?
So you would be able to, there is a solid fence on 2 sides of the property now, or one side of that property and one side of 256. Those have solid fences. I don't know what condition they're in, but they are solid fences. The side that doesn't have a fence currently is the side adjacent to the mixed use property, where Amanda's showing where her cursor is. And because the parking lot is visible from a residential structure through that side, you would have to provide screening there. There seems to be room to put up a fence, so I don't think that's insurmountable. That's why I was saying that it's the turnaround and the drop-off area and how the cars will queue that's a much more significant condition. There's also a requirement that there be a 5-foot perimeter buffer of landscaping around the building. That one will be impossible for the applicant to complete that. On the one side, on the southern side of the building is on the lot line. There's no 5 feet there to put any landscaping. In the rear of the building, you could put a 5-foot buffer, but now you further eat into the area that you're looking for your parking or your turnaround. And on the other side of the building, on the north side of the building, I don't believe you have room for a 5-foot buffer either. So, so it looks to me like you would need to ask for waivers of those requirements. And those apply to any property that has a proposed or an existing 10-lot parking spaces, 10 space parking lot. And that's what this building falls under. It has an existing 10 space parking lot, even though the parking spaces are not delineated. It has been used in the past to accommodate 10 parking spaces.
Thank you. And I guess my last question, and this is more of a procedural thing, as far as for us, at what point would the building commissioner be making the determination on what type of use this is? Because I think that is important for our next conversation around parking.
I believe he would need a complete a business plan to make that determination. So
Okay.
if there's anything that has not yet been submitted, that describes the business itself, that needs to be submitted.
Thank you.
I would like that kind of contemporaneous with all the other issues. That it's just because I think that does have an impact on our considerations.
Thank you. Any other feedback or questions for the applicant team, just so that they have everything from us before they return? And any other public comment? I didn't see any hands raised. I didn't see anything else in the Q&A. All right. If there's no other feedback or questions or comments, then I think I would entertain a motion at this time.
Madam Chair, can I ask what the possible dates are, and is there a feeling among either the members of the board or staff that going to the next date may not be sufficient time for review, for us to produce the information, and for staff and other departments to review it?
It's an excellent.
I don't know what your schedule is, so if you could.
Right, my apologies.
Me.
We should have that conversation before we make a motion to continue the hearing to a particular date. Nora, Amanda, what are the next few dates coming
Your
up?
next meeting is on May 19th, and then you have meetings after that on June 2nd and June 23rd.
Thank you. I guess the question is I would prefer the next time we have this conversation to have plans that are a little bit more real, like with everything, with measurements, with something that would be submittable or approvable and not conceptual, so that we can have a really concrete conversation around it. So I guess that's the question for you and your team, is how long do you think it would take you to go and do the measurements and try and design a turn that would actually be usable, or parking spaces, or whatever direction you choose?
And to have us have adequate time for review.
So May 19th is 4 weeks, and then you said June 2nd is 2 weeks after that, and then June 23rd is 3 weeks after that. But did I get those dates right?
That's right.
I don't know whether Yiting or Shang, do you think that with the engineers and the other information that's required, whether May 19th makes sense, or is June 2nd? And these are all Tuesdays, I think.
Yes, we meet Tuesday evenings.
Yeah. Either one of you have a feeling about how much time it would take? I apologize, but I'm new to this particular case. Whether we could get stuff put together and in, because I imagine staff wants it a week or so at least before the hearing, to circulate it within the departments and to send it out to the members. So it really means we'd have to have stuff in within a couple of weeks where we are now. 3 weeks from now, Nora, would 1 week before a hearing be sufficient, or what do you normally want?
1 week before is fine.
Okay. So we'd have to have everything in by the 12th of May, or otherwise we go off to the hearing date of June 2nd, where we'd have to have everything in place submitted by at least the 26th of May. Shang, do you have a thought on that?
But I think we can do June 2nd.
Go for June 2nd?
Yeah.
All right. I think that makes sense. Yiting, I think the same way? All right, Madam Chair, if we could ask for a continuance to June 2nd, and with the understanding also that we need to file everything with the planning department 1 week before. We would ask for June 2nd at 7 o'clock.
That's perfect. Thank you. And it looks like our staff has a motion ready.
Oh,
I move that the planning board continue the public hearing for the requested limited environmental impact and design review, LEIDR, approval for the proposed, that's small, Nora.
Oh, sorry.
I'm sorry, even with my glasses. There we go. Foresight Child Care Facility at 260 Washington Street, as described in the incomplete application, therefore submitted to the planning board. To the planning board meeting on Tuesday, June 2nd, 2026 at 7 p.m. via Zoom, where a Zoom link and associated call-in numbers will be provided on the town's calendar at westwoodma.gov. Maureen, you need to unmute. Oh, Tim got it. Tim got you.
Thank you. I did hear a second. I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Maureen?
Aye.
Bill?
Aye.
Tim?
Aye.
I vote aye as well. That motion carries and the hearing is continued. Just for a point of order, Nora, I know we're down one member, but if Mike watches the meeting and signs the paperwork, he can participate next time.
He can, yes. He would need to sign an affidavit saying that he'd reviewed the meeting recording.
Okay, great. So hopefully next time we should have all 5 members. Excellent.
thank you very much tonight.
Thank you.
Time tonight, and we'll see you June 2nd.
Thank you,
Indeed.
everyone.
Thank you very
Thank
much.
you so
Bye.
much.
Bye-bye.
Thanks.
All right. Then our next agenda item was 22 Everett Street, continuation of the public hearing for consideration of amendment to mixed-use multifamily residential overlay district, MUMFROD special permit for the block at 22 Everett, 22 and 40 Everett Street to relocate and downsize the playground, adjust landscaping, and increase number of off-street parking spaces, continued from April 7th, 2026. But I believe we heard at the beginning that we are going to continue that public hearing without discussion to May 19th.
Maureen, you want to take it?
Yes. Am I on mute? No. Okay.
No, you're not. You're good.
I move that the planning board continue the public hearing for the requested amendments to the mixed-use multifamily residential overlay district, MUMFROD, special permit and consolidated earth material movement, environmental impact and design review, EIDR approval for the block at 22 and 40 Everett Street, as described in the application, therefore submitted to the planning board and filed with the town clerk on December 9, 2025. To the planning board meeting on Tuesday, May 19, 2026 at 7 p.m. via Zoom, where a Zoom link and associated call-in numbers will be provided on the town's calendar at westwoodma.gov.
Second.
Thank you. I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Phil?
Aye.
Tim?
Aye.
Maureen?
Aye.
Vote aye as well. That motion carries and that hearing is continued. And that is not my browser. Sorry, clicked on the wrong window. Our next agenda item is rules and regulations. Continuation of public hearing for consideration of amendments to various planning board rules and regulations, standards, guidelines, and meeting procedures, continued from April 7th, 2026. And there's a whole pile of them. As Mike is not here, and I know he was working on some of the language in the planning board rules and regs, I think, unless anyone strongly objects, it makes sense to table that one. But then we still had EIDR and special permit on our agenda. So we can move forward with those, unless anyone has other ideas. It's democracy. So I'm not seeing anyone saying no. So, all right. Nora, Amanda, do you have a preference whether we start with EIDR or special permit?
Why don't we start with special permit?
I'll let you all can take the lead here.
You do your presentation.
Thank you.
All right, so these are the special permit regulations. I received comments from one board member, Maureen, who reviewed these pretty thoroughly, so I appreciate that, Maureen, and she found 2 typos which have since been corrected. The first typo was in the fee section. Let me find that. Section 1.3. No, I'm sorry.
3.1.
3.1. Thank you.
Mhm.
3.1 had, in addition to all of the special permits listed here, had a reference to the major business development special permit. Major business development was eliminated in last year's town meeting, so it no longer has to be in the special permit section. So that's been pulled out. And then the other change, Maureen, do you have the number in front of you? There was a incorrect citation.
Yeah, section 3.1, what, the authority for administrative review typo? Oh, did you fix that typo?
I fixed that typo as well. So what was the number 3.1? Was that was,
Yeah.
I'm sorry, that was an EIDR. That was not in special permit.
Oh,
This
that's
was the
right.
only change that was made to the special permit to correct 3.1 application fees to remove the reference to major residential development. So most of the changes to the special permit regulations have to do with bringing them into conformance with our electronic permitting requirements. So it's mostly language that talks about the application submittal requirements. Don't want to make anybody dizzy here. Application requirements right here. So this is the biggest change in the bylaw. It used to say that it required paper copies of applications and a certain number of paper copies, and now it's simply applications are submitted by the electronic application portal. That is the biggest change in this section. There are other changes that have been made to remove sections that we no longer deal with, like the major business development special permit is no longer a thing. Neither is the earth material movement special permit, which is in the current special permit regulations that were uploaded, approved by the board in 2015. At that time, special permits were required for earth material movement. Sometime after 2015, the board changed that to EIDR approval for earth material movement, and then even more recently it was changed to an administrative EIDR approval. So that's been taken completely out of the special permit requirements and has been, we've drafted an independent set of rules and regulations for administrative earth material movement approvals. But if you look through the sections of the regulations, there are other minor changes just to bring all of your rules and regulations into conformance using the same terms throughout the text, but nothing is as substantial as changing to electronic application submittal, which in practice we have been doing since 2017.
Which in practice is not a material change. I mean, it just is catching up with the world. I had one question on the fees.
Yes.
Could we scroll up to that?
Yep. So the application fees here are not changed. If the board would like to change the fees, they have an opportunity to do that.
You're reading my mind a little bit. Or language for future adjustment, I guess, was another thing I was considering without necessarily and I'm open to suggestions because I was looking at the fees and then I was saying to myself, I mean, the world has just gotten very expensive and we don't necessarily, I mean, in the scheme of some of the things that we consider, these are minor costs. But without necessarily having a kind of, what was it, a entire board process, is there language or consideration for adjustment of fees over time, I guess, is a mechanism. And I didn't take the time to try to, draft something, but an adjustment that, because if we don't consider this for 10 years, these fees are just not going to keep up with what costs are.
So these are the fees that we put into play in 2015. They were adjusted then. They have not been adjusted since then. And our thinking behind not adjusting them is that the cost of employee time spent reviewing the fees has not grown to the same extent that the cost of advertising applications has. So an applicant already has a substantially increased cost in applying to the planning board because of the need to apply for the need to advertise the application in the local newspaper. So,
Right.
10 years ago, we had a couple of different newspaper options, and the costs were maybe $150 to $200 for an advertisement. And now it's at a minimum $400, and depending on the language that has to go into the ad, it can be as much as $1,000 for an applicant to have their advertisement. So in order to keep costs down, we chose not to recommend an increase in the application fees. To go to the question of how you could have it done in a way that doesn't require an opening of a public hearing, that would come into this section 1.3 that discusses adoption and amendment of the rules and regulations. You could put a carve out in that section that would allow, except for fee adjustments, which could be done by posting on an agenda at a regular planning board member meeting. You could do that if you want to. It would be inconsistent with how the town has approached fees in the past. We have always held public hearings for considering changes to fees, not just these fees, but fees for building
In
permits.
general, yeah.
Yeah. So we always have a public hearing, so that would be a change in procedure.
I know where, what was it, last year or the year before, where we had a publication and then there was either an error in it, there was, and
Yes.
we were really tight. I mean, it was just a kind of tight issue. And I was saying to myself, boy, we're really, tight on, and if we adjusted fees, maybe that could give us at least a little bit of flexibility. But I hear you, what you're saying. I just toss it out for consideration. And that was my only thought.
So just one other thing I'd point out there. So fees may increase. If you choose to increase the fees, you can increase them, but that doesn't mean the money becomes available for payment of planning board related costs. Let's go into the general fund. The money we have available for advertisements, that in that case, it was an advertisement of, I believe it was a zoning. We had a couple of problems. We had one with a zoning amendment hearing, and we had another problem with just an applicant's hearing where there was a date that was advertised wrong. So we had to cover the cost of the re-advertisement for that. But that comes out of our budget. Budget is voted by town meeting, and it's really does not have any relation to the fees that are taken in to the general fund.
Right. So, okay, that makes sense. I just wanted to, that was my only issue. I just, raised it as a small, but if I mean, holding the line since 2015 to now, I mean, costs are, 2x or who knows what since, the last 11 years. And if we held it for like another 10 years, they really are going to be a small cost.
Yeah.
They're not keeping up.
I agree with that, but you also can hold a hearing anytime you want to change the fees.
Right.
It would simply be the cost of the advertisement that we would have to cover.
But otherwise, I have no other issues.
Thanks, Phil. I see Maureen's hand up. By the way, Maureen, gold star for finding that.
Thank you.
You're
Nora, on the fees, I forget you said once, those are comparable to what other towns charge, correct? Is that how you determined what the fees were to begin with?
Yeah, they're generally comparable. So 10 years ago, 11 years ago, we did do a study where we looked at other towns. Everyone's zoning bylaws are slightly different. The way they attack their review is a little bit different. Some towns have a design review board in addition to their planning board that requires additional fees. So they're not all apples to apples, but we thought that our fees were definitely in line. The overall project fees were in line with our peer communities. They might not be exactly the same because we have EIDR, which is a little bit different. Some other towns have site plan review and design review. But generally our fees are more or less in keeping with what applicants are willing to pay.
Thank you.
Thank you. I'm not seeing any other hands up. Any other board member or staff? Anyone comments on these?
For anyone in the public, the copies are available in the meeting packet. So if you wanted to flip through page by page, you could do that.
Thank you. And I guess as this is a public hearing, I guess I'll open to public comment on this particular set of rules and regs on special permits. If anyone from the public would like to comment on this, please raise your hand and we can enable you to speak, or use the Q&A section of the Zoom app. We would just need your full name and address. We'll give that a minute, and then if we don't see anything, we can move on to EIDR. One of my favorite sections of the rules and regs. We do
Ellen, you need to get a life.
I know. Well, we do a lot of EIDR. I mean, that's like one of our big, aside from special permits of other kinds, that's one of our biggies, that in the EMM, or the combinations, or all of the above. So this section, I was really happy to actually have some new board members' eyes look at, frankly, because I've spent a lot of time in them. So I appreciate that we have people who have not taking a good look at them and potentially finding things.
I repeat, you need to get a life.
I know. This is my respite from a lot of other things. I actually really enjoy reading rules and regulations.
They're mind-boggling.
I'm a person who appreciates order, so I like rules and regs. And I do not see any public comment on the previous set. So Nora, the floor is yours.
Okay, so this is another one where Maureen found a typo. And Maureen, if you can tell me again, that was section 3.1 again, or? It was the administrative authority for administrative approval. Here it is. It was section 3.1. This reference right here to section 7.2.6 had previously said 7.2.2.6. So we just made a mistake, or it might have even said 7.22.6, right? Yeah,
Right.
so there was just an extra 2 in there, which has now been removed. And I think that was the
Oh, and yes, the other comment was that this used to be 7.3.
yes.
So in the packet that the new members have, if you've got your papers, it's now up to 7.2 and everything, because that used to be BD?
Major business development was 7.2 and EIDR was 7.3. So when we remove 7.2, major business development, then section 7.3 was renumbered 7.2. So yes, every board member will get a full set of the new rules and regulations to replace the ones they have in their binders now, once they're approved. And in this case, the big changes to the numbering. Other than that, the changes here are just like the changes to the special permit. The biggest change is change to electronic permitting. Another change has to do with the applicability. So we have solar design review used to be part of an EIDR that's been pulled out, and it has its own set of rules and regulations now. So these regulations apply to general EIDR approval, limited EIDR approval, which we just had an application tonight, administrative EIDR approval, open space residential development EIDR approval, wireless communications overlay district EIDR approval, and mixed use and multifamily residential overlay district EIDR approval. That's another one that's new to this section of rules and regulations. We didn't have that back in 2015.
Nora, I had a question on section 5.3, and it only came to mind now that I feel like we're becoming more privy to, thanks to your emails, of some of the other public hearings in abutting neighborhoods. I was just curious, is there a similar construct in the abutting towns and communities that we get notified through this mechanism, or what? I just out of curiosity.
So for special permits, there is. For site plan review, that's not a state requirement. We choose to abide by it. So for all applications, we give notice to our abutting communities. Some of our budding communities give notice to us for site plan review applications. In our case, we call it EIDR. Others do not. The state law only pertains to special permits. So if any town in any community that touches us, so that's Norwood, Canton, Walpole, Dover, Needham,
Yeah.
and Norwood, that all of those towns have to send us notice whenever they have a special permit hearing.
Gotcha. But beyond
Mhm.
special permit, is that something that we could advocate for? Or I guess I'm not as familiar with how those discussions or town interactions go.
Yeah, so it's up to a town to decide. We were advised, and the reason it's in here, town council many years ago gave us the opinion that our EIDR process follows the state law on special permit review, and so we should track it the same way, and we should have our notice requirements be equivalent. So
Okay.
that's what we have always done. Some of our neighboring communities seem to have gotten different opinions from their council.
Got it. Okay. I was just curious how that how that comes up and how we can advocate to make sure that we're in the know of because again, a lot of these sites are like the examples you sent
Yeah,
play a big role right in our community as well. So
absolutely. There's not an artificial boundary between one town and the next.
Yep, it can affect traffic. It can affect residential
Yeah.
use, sometimes in a positive way, sometimes in a negative way.
Yeah. Yeah, I think that's something to be discussed further, just especially on our neighboring towns.
but
So
I guess as a follow-up, then I guess how does that process of advocating for those types of not for these special permits, I understand, but for
Mhm.
for other
other
types of
site
hearings,
plan review.
how do we go about like advocating for that?
So I think we would do it through our boards approaching the other towns' boards or through staff doing the same. So we have the trick meetings every month where representatives from those towns are all in attendance at those meetings. And that would be a great opportunity to speak to the staff of the other community. And in some cases, board members are also in attendance at those trick meetings. And we can discuss with them the next time that they're ready to update their rules and regulations, our interest in having them add the requirement to notify abutting communities of all their applications, not just special permits.
Got it. Okay. Thank you.
Actually, that's a piggyback question that's not quite related to this. You mentioned Trick. Do we have anyone attending those meetings currently?
Not since Elijah has left. Elijah attended occasionally. He did not attend all of the meetings. He attended occasionally. And since he left, we do not currently have another staff member who's able to attend. I believe we do have a planning board representative who is the alternate. And I believe that's Mike. Am I correct, or is that Phil? I have it on the
Could
list
be.
we gave
I
to the
was.
select board. It was Sean Weller. So when
Right.
Sean left,
Oh, because I was about to turn my camera and mute myself because I thought it was me. So goodbye. I'm going away.
I don't know if it's you or if it's Mike.
Just not to divert, but I think Steve Olenoff goes, so maybe we can reach out to him and just talk to him about a presence to make sure, because I agree with you, Tim. I think we're seeing that more and more. There's a lot of projects kind of coming up on our border, be they local to the town or like we're seeing there's a MassDOT project coming up. So I think it's good for us to really be aware. Because we're trying to do that. It would be nice to advocate so that we get really proper notice and the ability for our residents or us to go and participate in those conversations
Yeah.
as much
Yeah,
as possible.
especially if we're already, taking a stance of being more inclusive, we may as well use that as, not leverage, but as effort in good faith, right, to have other towns do the same. So.
Agree. I think it just benefits everybody. In my opinion, it's better for all of the communities involved if we're all kind of talking to each other.
Yeah.
So,
Outside of that, I had no other comments. I just that struck me as of interest given some of the recent emails.
yeah, no, thank you. I thought that was an interesting perspective, and I agree with you.
What towns now do that? besides us? Like, are any of the surrounding towns doing that right now?
I can tell you, I have not read through the
Oh.
regulations for any of the abutting towns. I know that some towns seem to give us more notice than others. I believe Needham provides us quite a few notices. I'll have to look through them as they come in to see how many of them are site plan review. I think Walpole might also. And then we have a very good relationship with Norwood, where the planning director in Norwood was the former housing planner in Westwood. So I'm in frequent contact with Sarah Dixon, and she lets me know of whatever's coming up before we even get a notice. So that's helpful.
Yeah.
But there are other communities. Dover, I don't recall seeing very many notices coming from them, but then again, Dover doesn't have all that much development in comparison to some of the other communities. Canton, I don't believe notifies us of anything other than special permits.
Thank you. Any other board member questions or comments on this particular set of rules and regs? Seeing no hands, I will open it up to public comment on this particular set of rules and regs. If any member of the public would like to comment or ask a question, please raise your hand or use the Q&A, full name and address for the record. We can give that a minute. And then I think we have some action to take. Barring any public comment, I believe we have action to take. Yes, Nora?
Yes, we do. We would be looking for you to grant approval of these two sets, the Environmental Impact Design Review Regulations and the Special Permit Granting Authority Rules and Regulations, and then continue the hearing to, I'm going to recommend June 2nd. But if the board feels like they could do it on May 19th, I'm happy to do that and just limit the number of regulations you take into consideration.
I would love to nail down the planning board policies and procedures so that we can start kind of managing our agendas.
Okay.
So we could at least put that one, unless anyone objects, if we could at least put that one on May 19th, because I don't know what our agenda is shaping up for that evening, aside from board reorganization. Sorry.
Oh, that's right.
It's our annual game of not it. But
Okay.
aside from that, I don't know what our agenda is looking at, but I think hopefully because we've discussed planning board policies and procedures quite a bit already, I would hope that we'd be able to kind of put a pin in that one relatively quickly. But I would advocate for getting that one on that agenda.
Okay, so far your agenda on the 19th would be the board's reorganization, and then you just continued 2240 Everett Street to the 19th. So that would be on that meeting as well, and that's it. So you would have room to take up rules and regulations on the 19th. In that case, I recommend that maybe you consider the planning board policies and procedures, as well as the what I consider the next most significant set, which is the scenic road rules and regulations. That's the one that's most likely to come into play in the near future.
That would make sense. I think those two probably need to go next in the queue.
Yeah, I agree, unless anyone objects, but it sounds like our agenda is light enough, at least today, that we could devote significant time to both of those if we needed to.
Yes, I think the June 2nd agenda will be a little bit more full. You have this, the hearing for Foresight that was continued, and I believe you have a new application hearing coming up on the 2nd as well.
Okay, thank you.
Maybe that'll give us time to discuss the 40Y a little bit.
Mm-hmm.
Yes. All right, then we have a couple of motions to entertain, so whomever would like to make the first one.
Did we ask for public? Do we even have public comment?
We asked, unless I'm cracking up, but I'm pretty sure I put it out
Oh,
there.
you did. Okay.
You
Comment.
did.
You did. Oh, okay. Then I'm the one
Always
cracking
good to double check.
up.
Colin.
I'm the one cracking up. Don't worry about it, Ellen.
No, but I prefer it's nobody commented, so it's always best to ask just to make sure.
Just to make sure.
I would rather you cross my T and dot my I rather than us skip it. So, okay, good. So we did ask for public participation. There was no public comment on either of the sets of rules and regs for tonight. So
There we go.
Great.
Go ahead, Tim. No, I talk too much. Go ahead.
I move that the planning board adopt the following sets of rules, regulations, standards, and guidelines as revised at the April 21st, 2026 public hearing session. Environmental impact and design review rules and regulations, special permit granting authority rules and regulations.
Second.
Thank you. I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Tim?
Aye.
Maureen?
Aye.
Bill?
Aye.
I vote aye as well. That motion carries. We have another motion.
I move that the planning board continue the public hearing for amendments to various planning board rules and regulations, standards, guidelines, and meeting procedures to the planning board meeting, which will be held via Zoom on Tuesday, May 19th, 2026 at 7 p.m., where a Zoom link and associated call-in numbers will be provided on the town's calendar on the homepage at www.townhall.westwood.ma.us.
Thank you very much.
Second.
I have a motion and a second. Any further discussion? Seeing none, I'll take roll call. Phil?
Aye.
Maureen?
Aye.
Tim?
Aye.
I vote aye as well. The motion carries and that hearing is continued. So I'll put in the plug for planning board policies and procedures and scenic road regulations. If folks have feedback, comments, questions, please send to staff ahead of the next meeting.
That would be very helpful. And then for these 2 sets you just approved, we will have them at the police station tomorrow. So go stop by whenever you can and sign them, and that way we'll get them recorded and they will become official.
Excellent. Thank you. So now I believe we actually have time tonight to have the 40Y discussion, but as it is about 9:15, I would really love if we could take a 3-minute break before, no, because I really want to focus on this conversation, and I think it would be good if we take 3 minutes to kind of stretch and whatever, as long as nobody objects.
Second.
Agreed.
I can't make that motion, but if someone would,
I move for a 3-minute bathroom break.
Second.
motion and a second, any further discussion? Seeing none, roll call. Phil?
Aye.
Maureen?
Aye.
Tim?
Aye.
Vote aye as well. We will be back in about 3 minutes.
Thank you.
show that we reconvened at 9:17 p.m. Thank you. All right. And with that, our next agenda item is 40Y, discussion of exploration of Chapter 40Y Starter Home Zoning District. Is Amanda?
Amanda will lead this.
Oh,
Yes.
thank you.
Okay, so tonight is meant to be an introduction only. It's, a pretty substantial zoning mechanism. So tonight's just to begin that conversation. We're not going to flesh out everything. So I'm just going to provide a high-level overview, drawing from the memo that I had given you. I think it was at the end of March. So this law was enacted in 2023. And they just recently released the regulations this past spring. It's kind of like a 40R district in that it's optional for municipalities to adopt, though the housing production plan, which has now been adopted by the planning board and the select board, did call for exploring this. And it's a tool to create by right single family starter home zoning districts. And in some cases, you can have a mixed use component of that. The calculations for it are much simpler than MBTA communities. Essentially, it's based on what is currently allowed in a certain area of land, what would be allowed if you were to apply 40Y, and then the incentive units are the difference between those two. And where that comes into play is the incentive payments that come along with adopting this. Size and boundaries, they're much more vague about the requirements. So they say it has to be of reasonable size, and they put a max on no more than 15% of the entire land area of the municipality, but they don't set a minimum. So it's a lot more open to interpretation this time around compared to MBTA communities. And we would never have to worry about reaching that 15% threshold because that would be well over 1,000 acres. You do have to follow parcel lines, so you can't cut a parcel in half. And you have to allow at least 4 units per acre by right. Like MBTA communities, they do define developable land. So in other words, they don't want you picking an area that is almost entirely water or conservation land or not actually developable in some way. So that's an important consideration in this. Just in terms of unit features, I want to call out that the max square footage on each unit is about 1,850 square feet. 50% of the units have to have 3 bedrooms or more, and ADUs are not included. ADUs are still protected by right in this district as well, so nothing changes about that. But they don't count towards your unit count. You can't have any occupancy restrictions on age or protected classes. So it couldn't be all senior housing, for example. If there are at least 12 units, at least 10% must be affordable. We could apply our own restrictions as long as it's meeting that minimum. And jumping down to design standards. Essentially what it's saying is you can't regulate a starter home district any more than you would regulate single family homes in any other area of town. So you can still look at things like buffer zones and scale, setbacks, all the usual things you can regulate. I also want to draw your attention to the approval process. So it's similar to MBTA communities in that it's not just as simple as the town adopting it and then it moves forward. It starts with a preliminary determination of eligibility. This is something that the town would apply for. It's quite extensive. You have to have your map ready of what the district boundary will be, a narrative of the developable land, the actual bylaw language that you intend to propose to the town. And there's also additional exhibits that they require. Once you submit that as a community, EOHLC, which is the entity that oversees this, will issue a letter of eligibility or denial. They have to issue that within 45 days of receiving a complete preliminary determination application, unless they ask for more time. No communities have gone through this yet, so we haven't seen what this looks like in practice in terms of timeline. But it wouldn't be out of character for them to request more time. So that 45 days isn't necessarily a guarantee. Once you have that letter of eligibility, so assuming they didn't deny you, you then have to adopt it as a community. So in our case, that would be bringing it to town meeting. You have 3 years from receiving that letter of eligibility for town meeting to pass it. Then, once town meeting has passed it, you apply for starter home zoning approval. This is similar to how with MBTA communities, town meeting passed it, and then we had to submit what's called a compliance model. This is a similar process. So we fill out a form, which they haven't released yet, but it's something that would be more on the staff side of things. And we would indicate if anything has changed since our initial determination. So you are allowed to make changes between receiving that letter of eligibility and actually passing it, although it's not necessarily said explicitly, but I'm assuming if you're going to make substantial changes between that time, you probably have to consult with the state. And then finally, HLC will issue a final starter home zoning approval. They have to do that approval or denial within 30 days of receipt of a complete form from the town. And it's once you start building the units that the payments start coming in. So kind of like some of the other zoning initiatives, if you make changes, you do have to notify the state. They do have differentiate between non-substantial changes and substantial changes. And then the payments are tied to the incentive units. So the incentive units, again, are the ones that were built as a result of adopting 40Y that wouldn't have been able to been built previously. So if you apply it to a district that already allows 4 units per acre by right, we don't have a situation necessarily like that, but if we had that, you couldn't get any incentive payment. There has to be that difference met. And it's 3,000 per unit for those production bonuses. And then you have to submit basically an annual update of your progress of actually implementing that district in terms of actual construction. So the big thing is the state can take this away. So just adopting it isn't enough. You actually have to see units being built. They can issue a letter of non-compliance, or the next step would be a certificate of revocation if you've not complied or no longer comply with the requirements of Chapter 40Y. So if you've changed something that no longer meets those requirements. If the town has appealed or amended the district in any way that changes the number of units, that can lead to a revocation. If you have not issued building permits within 5 years of receiving final starter home zoning approval, which is that last step in the approval process, they can as well. And then also, if you have issued a building permit but not issued a certificate of occupancy within 2 years of the building permit. So if number 3 or 4 are the issue, you can submit documentation to say it is moving along. So there is some wiggle room, but this is the biggest piece with all that in terms of planning. It's not just a matter of making a zoning change, it's having a plan to actually see the development come to fruition. So with that, I'll hand it back over to you, Ellen, and I'm happy to answer any questions, but I just want to emphasize tonight is introductory. There's a lot to unpack here.
Thank you. No, that was a nice overview because I kind of read through it and it was super dense. So I appreciate you kind of framing it. So yes, thank you. I'd like to open up the floor to board members. Are there questions, thoughts, comments, etc.?
Amanda, talk to me conceptually about the revocation or why, because parts of that may not be within the control of the town, meaning we can take all the steps that and we can do everything we can try to do, but that doesn't necessarily mean that we're going to actually have permits. The whole thing could still be sitting there. What conceptually, though, is the purpose or the goal of having revocation?
It's because this zoning change is tied to funding, and so the state doesn't want to be providing funding to a community if they're not seeing the results that were promised as a result of that. If there was no funding piece of this, I think it would be very different. But that's what I think it's about.
And I hear you, and I assumed that was the answer. But funding doesn't necessarily mean that we're going to have John Jones or Giorgio or anybody else coming in and all of a sudden start the process. It just seems, I don't know. I just, that was the piece that I really had some difficulty understanding conceptually, because this is a tool and you're saying we'll take the tool away, which doesn't make sense to me. Sometimes, we might create, Everett Street, but then it takes, a number of years for us to do another MBTA communities project. And it doesn't mean all of a sudden you take away the MBTA communities tool. I mean, it's kind of crazy. So anyways, that was my thoughts. There's a lot there to unpack though, and I'm interested in more of a dive as we get into it.
Yeah, I just will add that I communicated with the planner from Mansfield because they had pursued this in the fall, and then ultimately decided against it. At least for now, they just tabled it. They weren't abandoning it altogether. And in their case, they had a developer basically be a partner in the process from the beginning. So that there was a little more of a guarantee of results, but they also were operating under a time where before regulations were released and finalized. So there were just a lot of unknowns, but that was their strategy.
Is there a conflict if we quote unquote partner with a developer as compared to, I mean, not that I don't think it's inappropriate. I just wonder, because there's differing interests between the town and a particular developer entity that may have, a financial interest in a certain way things be structured.
So there's nothing against it. They were, the state was well aware that Mansfield was taking that approach. And the state did specify that you don't necessarily have to have a developer lined up to pass it, although process-wise, I'm not really sure how you could do that without having something lined up. But yeah, you could do it. The thing you have to be mindful around is obviously there's the issue of finding land that's suitable for this, but also
Right.
if it ends up being private land that's of interest, the property owner would have to consent to it, but there would be you just have to be mindful of that process depending on who owns the land currently.
But the developer might have interest in private land, but the private landowner may not have interest in the developer, and we're kind of in the middle.
Right.
Okay. A lot there, I think, still needs more consideration.
Thank you, Phil. Tim?
Yeah, can I just ask, do we have a sense of what the magnitude of these zoning incentive payments are from I know, I understand it's like there's calculations and a methodology, but what's the magnitude that we're talking about?
It ultimately depends on how large the district is and the number of units and what is already permitted on that site. So, it's 3,000 per bonus unit, and the bonus units are the ones built beyond the incentive units. So, there's a lot of different factors at play. It's hard to ballpark exactly what
Yeah.
magnitude
I
it
just
would be.
yeah, no, I know it's probably an unfair question,
Yeah.
but in my mind that that's an important factor in determining, right? Like that's the whole a couple other questions, I guess. What from an infrastructure standpoint, are these, I'm just trying to get my head around I did a little bit of research and so these are very small, super small lots, decent, small houses. I can draw a point of reference. It's the size of my house with four of them on the size of my quarter-acre lot. These are tight. And from an infrastructure standpoint, I guess maybe it's again, an unfair question since there hasn't been folks going through with this, but I would just be curious what kind of, you know, how much this pushes certain elements of stormwater, wastewater, roads themselves. What would the structure look like, and how that weighs in? There's a lot of unknowns in my mind. These are tight areas, so not really a question. I'm just thinking out loud.
Well, without identification of the land, I'm not sure where we go.
Yeah.
I mean, Amanda,
it all
correct me if I'm
depends.
wrong. Without us actually looking at parcels,
Yeah,
we
can't.
kind of were stillborn, so to speak.
Yeah.
Yeah, land is your number one challenge in all of this, because Westwood is largely built out, or protected under conservation land. So you do have limitations. One parcel of consideration, and we're not asking anyone to make any decisions tonight by any means, but just looking at the process we did for the housing production plan, the mass dot parcel is an opportunity, but that's not without its implications for, getting public support for redevelopment in the Islington area.
Yeah.
So, that's
that seems
land
to be
is your, sorry.
But no, the Mascot property, in all honesty, because I was looking at a map when thinking about coming up for the meeting, I was struggling to identify something else besides that. And if anybody else, I mean, we still have a long way to go, so I don't know where else.
Yeah, it just seems like you'd have to build the infrastructure, or it's not just as simple as the houses. The development, I think, goes well beyond just the dwelling, right? And so I think it would take a lot, and I think that's obviously part of it.
Yeah.
Maybe the last thing on my mind, again, having researched this a little bit, I struggle with understanding the economics here as far as from a property value standpoint. And if the goal, right, is affordable housing, I don't know if this model, and I guess it hasn't been proven yet, right? That's step one. But I don't know if this necessarily solves that, problem in a town like ours where close proximity to highways, Boston, suburban nature. It seems like even if you dice up a property to really small, or to a small zone, small dwelling, I still think it's going to demand. I know there's a allocation that would need to be classified as affordable. I think the rest of them honestly would fall outside what most people would be considered affordable, and I don't know if it necessarily creates I don't know if it addresses the attempt to hit the affordability concern. In my mind, I feel like it just creates more similar sized houses in a denser area that already exist in certain parts of town. So I struggle with understanding if the economics would work, and from a value standpoint, if it even would open up a lot of doors. So.
Yeah, so the cost outweigh the benefit.
What's that?
Yeah, would the cost outweigh the benefit in the long run?
Yeah, right. Like I would think these would still demand a fairly
Still a fair,
yeah. I don't know if it's I could see this working in other communities, to be honest, with more space and lower property values. I don't know if the economics work.
Well,
I'm just talking out loud.
No, you might get a queuing of people that bid on properties that just drive up the price, which kind of eliminates the idea of making it a starter home.
Yes.
So somebody says, well, I want to get into Westwood because of the schools, or I want to get into Westwood for whatever property appreciation, as compared to Franklin or some other town. And then they, even though it's smaller lot size, smaller, square footage, et cetera, it ends up almost bid up to a higher point than an affordable point. That's
I know that's the kind of thing where I feel like I'd want to. I have a lot of questions of if it would work in a community like ours. So I know this is just an introduction. I just don't think I would be in favor of Westwood being on the forefront of exploring this without, if it sounds like there's other communities moving, and it would be interesting to see how those progress, what the profile of those communities are, and which have more success than others. I guess I would just be hesitant to be a first mover in an area where I feel like I have some concerns. That's all.
I think the Mass DOT property is a potential opportunity, but I've thought more about the developer partner issue, and that strikes me as a kind of material part of this entire piece. If we don't have if we don't have that in place, I'm not sure where we go next. Amanda, correct me if I'm wrong. I'm a big advocate, a conceptual big advocate, but when you start getting to real boiling down to where and when and how, it makes it harder.
Yeah, so these are all valid concerns. I mean, Tim, to your point, it's not necessarily a guarantee that just because they're starter homes that they'll be affordable. Which I would say the other question is, what are you looking to get out of the district? Because on one hand, you might get some affordable units, which would be beneficial because we are expected to lose some of our affordable home ownership units down the road when those deed riders expire. But the market rate units might still be quite expensive. On the other hand, we have people in the community who have been really asking for the smaller homes in Westwood to be preserved. And so this is the first time we've had a tool to say no greater than 1,850 square feet. So it goes back to what is it that the planning board wants to see out of this district if they were to pursue it. And I don't think there's a wrong answer. And then, I would be hesitant just in terms of process to not have a plan in place for actual development to go down that road. At the same time, I think, have to start putting out feelers. So it's one of those things like you have to start the conversation to find out if there's people interested in partnering in that capacity. But then you also have to be mindful of where you're going to do it and how do you decide, what step comes first? Is it identifying land? Is it finding a partner that, potential developer? There's multiple ways you can go about it, but I would be hesitant to just start it without one of those pieces in place.
I think you need to have the partner in place because the partner is going to have some input in the land, because without the developer partner's input, you're going to come to a dead end somehow. So it strikes me as the partnering is kind of the first consideration before other pieces then fall into, if they can fall into place, and that's not an easy way to go.
And one other program that the board may be able to take advantage of is the State Land for Homes program. So this is a newer program started by the governor where they asked all agencies to look at the state-owned land for underutilized land. And the MassDOT parcel has not been identified as one.
No.
But my understanding is there's a different process for that land then becoming developable for homes, rather than just the traditional RFP process. So that also might be a way into it where if you begin by identifying, say it is the MassDOT parcel, you begin that conversation with the state, they agree to release it through the State Homes for Land program. That's another way where you could find a potential partner as well. So all of this is new territory though, right? We're dealing with two new programs, so it's hard to say for sure how it would play out.
Would mixed use be available in that also?
So the mixed use component, it actually was interesting between the draft regulations and the final regulations. They put a lot less language around mixed use in the final regulations, and basically HLC has to sign off on any mixed use component, and the way I interpret it is it has to be accessory to the starter homes. So uses that are compatible to that. I think the closest example to what exists in our zoning bylaw today would be like how adult daycare is allowed in residential districts as an accessory use. I don't know if they would necessarily permit adult daycare, but that was essentially what they were saying, is it has to be accessory where the starter home district is still the primary use. So I don't think you can say there's storefronts and then some homes. I think it has to be
Homes with access. I was just,
Yeah.
I'm just thinking about, incentives, attractability, and sometimes if you have some mixed use, then you all of a sudden can create a greater opportunity to actually come into being as compared to not. That's why it's, but you're saying it can only be accessory. That makes it a little harder.
Well, that's what I was wondering too, because I think back to, and we talk fondly about like Carl's and the IGA, that there used to be like what's now the Banfield down by me used to be a little convenience store. And for those of us who had friends in these neighborhoods, you could walk up to it. So that's kind of what I was envisioning, is like if there was a little neighborhood, that maybe there was a little shop, and not like a strip mall, but like for mixed use, like
Yeah.
a little convenience store, but I don't know if that would be
Um,
considered an accessory use. I guess depending on how you did it, you could, but
It's certainly a question I can ask. I can reach out to the technical assistance team just to kind of get a little more clarification around it.
I think it would help. Because as Ellen's saying, I think if you have a little mixed use, it doesn't necessarily have to be a major portion of it, but I think it helps.
even if it's like an ice cream shop in the middle
Yeah,
of
somebody walks
the
around the
old
corner
street,
in the middle of the July and wants to get a chocolate sundae or something. I don't know. Or the little convenience store. Somebody would just want to pick something up.
because that's what I hear people miss. I mean, maybe it's just some of us of a certain age that remember being able to like, that it's now a house on the corner of, I think it's Circuit and Pond, which was great when, I was a terrible athlete. But, at the Sheehan Field, you could literally walk up to that. There was a house that had an accessory use of a little store. That was the IGA, and you could get a slushie or steak and cheese. So, like people, those of us who remember that, again, those of us of a certain age remember that. And that to me was a value add to the neighborhood. And like, I kind of wish it was there for all those kids who are playing soccer at the Sheehan. If you could just walk up the street and get a little slushie or something. When I read through this, I was like, maybe that's a way to kind of bring that back into a neighborhood in a way that doesn't actually burden the neighborhood, but enhances
It
it.
actually enhances that. Well, I was thinking the same. Tim's rolling his eyes at old people talking like this, but But that's
All the good
okay.
old days.
My
But
only
I think it's actually a great feature to the entire district or neighborhood.
that's what stuck out to, and I think in that particular example, it was an accessory use because it was a home with a little outbuilding that was the convenience store. So I really do, I think it's now all back to residential, that was a grandfathered use or something, but if that's the kind of, it's still possible, I guess, but I think some clarity would help. And I would be interested. So you said it's a minimum of 10% affordable, so that if as we do in other parts of our bylaw, if we were to look at 15, if that didn't kill the economics, that's something we could, if we were to look at something, if we were to talk to a developer, that's something we could ask for potentially.
Yeah, so that affordability requirement only kicks in if there are 12 or more units. So depending on the land you identify,
In the
it may
one
not kick
area?
in. Yeah, yeah. And um
So you
so
need to-
another thing to point out is right now our bylaw in select sections allows payment in lieu of meeting that requirement. You wouldn't be allowed to do that in this district. And if it's a phase project, so kind of like say Everett Street, for example, you have to meet that affordability requirement at each phase.
Okay.
Okay,
So
so that just okay.
I'll just add to obviously this is all
This
depends
is a
on
complex
the right
process.
the right site. It's a complicated process. You're right. I would just add, if we're talking about the MBTA or the train lot or whatever, I hear from a lot of
DOT.
residents about the amount of development in Islington area. We're digesting it. I do think it's going to take a little bit of time to digest. We're having these discussions tonight, lengthy, about traffic. The other day I sat on, like you all probably, on from East Street, almost backed up all the way to 95 to the intersection. There's just, and I know this is slightly different. I think it just a lot. I hear from a lot of residents concern about development speed and needing time to digest. So I think that's just another consideration too.
Yeah, I agree with you.
There's no question.
I know we've been talking about that, the salt staging area or whatever, but I don't necessarily, I wouldn't want to live right on Route 1. So I get that that's a 5-acre parcel of open land, but it wouldn't necessarily be my first choice. And I'm actually really sensitive to what you just said, Tim. I don't know if there's any land in Westwood, but I would personally be more interested in a piece of land that was not in Islington to look at for something to build a small new neighborhood. That's my personal preference. Again, I don't know if anybody has anything that they're interested in, but I would probably be more amenable to that than to that parcel on Route 1 for all of those reasons.
And Amanda, you said that the only other place or the only other town that has even attempted to do this was what, Mansfield? Anybody else?
So the final regulations weren't released, so there technically wasn't anything to move forward with. Mansfield, kind of like Westwood did when MBTA communities was passed, got a jump start on the process. And the only reason they ultimately tabled it, according to their planner, was just timeline. They were trying to meet a fall town meeting date and started it, I believe, I want to say it was summertime. And found that it's a very lengthy process. It's not like the traditional zoning amendment process where, start in December and, have something by the springtime for annual town meeting. You have a lot more that goes into it. And so they just felt like they needed more time. And also, I think probably certainty around the regulations as well. Because I remember I reached out to the state at the time and asked if HLC was even issuing approvals before the regulations were passed. And they hadn't really decided one way or the other, but they were willing to support communities who wanted to get a jump start on it. So it's still new territory. So there wouldn't be examples of communities that have done it yet.
I did a little AI screening and searching.
Oh, there we go. Now we're going down the real
Now we're
path.
done. Yes,
rabbit
no.
hole.
So I was trying to
I hate
figure
to
out
tell
if we
you
could.
when clients of mine do AI legal research, and then I
Yes.
immediately say that's completely wrong, and then I have an argument with them.
Not legal research, but I figured it could at least scrape like memos and minutes and whatnot. And there were a couple towns that it seemed like have at least had some level of discussion. I read like Methuen, Plymouth, Middleborough were a couple that came up that maybe probably hit on. They've had maybe a similar type discussion as this, but obviously I didn't do any digging further. But I was just curious, like how far out where the economics make sense of the land use and like just where this probably is more targeted.
Think now you got me interested. I want to look at some of those other towns. Middleborough is particularly intriguing to me. But I do see Nora's hand up. Sorry, Nora. It was
Just-
blending in with your background there.
Just a reminder, we're coming up close to 10 o'clock.
Well,
and
there you go. Nora's
Oh,
now the
whoa.
Yep,
timekeeper with the new
I
regs.
am. So we'd be happy to put this on your next agenda for further discussion. And in the
Because I think
meantime, you can all do
yeah,
your own research.
we
Sounds
have
like
a
we'll have
lot to talk
time
about.
at the next meeting as well. We should have time to pick this back up. And
Yeah.
thank you, if Tim, if you could just send that list, or they'll be in the minutes, right? So I would like to. I heard Methuen and Middleborough.
Plymouth and
Yeah,
Methuen, Plymouth, and
with the
Middleborough.
caveat that I did no actual vetting beyond what was
Was
produced.
on AI.
No, that's
Ellen, just put it in AI. They'll all pop
AI.
up.
so that gives us a direction. I actually know people in at least two of those towns, so I can that gives us a starting point.
Yeah.
I know. So thank you.
All
That's
right,
really
Nora's telling us to wrap it up. Come on,
I
wrap it
am.
up.
all right.
Wrap it up.
So we don't need to make any motions on that, right? We
Don't. No, it's just a
conversation.
discussion item, so we'll put it on your next agenda for further.
Go to minutes.
Excellent. Phil, take it easy.
You're so pushy.
All right. Our next agenda item is minutes. It was the draft minutes from April 7th, 2026. Did anyone have any edits or comments or changes?
I just had one question. I couldn't for the life of me figure out how many parking spaces does 22 and 40 Everett really, that has got me so confused. I'm not sure what number is supposed to be there.
So the discussion that we had came from the applicant saying that they had 2 spaces more than the approved plan. Now when we've actually counted up the spaces, we believe there are 3 spaces more, but that's an item for discussion at your next hearing. So for the purposes of the minutes, it was 2 spaces more than were on the approved plan. That's what they requested. That's what you approved. And that's what their decision shows.
Okay. Thank you. Other than that,
Thank you. But so that doesn't necessitate a change to the minutes, right? That's a future discussion. The minutes.
Right.
Meeting.
The minutes, I think the minutes accurately captured your decision.
Okay, great. All right. Good question. Any other discussion on the minutes? Okay, I'll entertain this motion.
I move that the planning board approve the minutes of the meeting of April 7, 2026 as presented.
Second.
I have a motion and a second. Any further discussion on the minutes? Seeing none, I'll take roll call. Maureen?
Aye.
Bill?
Aye.
Tim?
Aye.
I vote aye as well. Great, that motion carries. All right, next agenda item is agency and committee updates. Have any representatives been to any meetings that they would like to report out on?
No.
Me.
Nora and I did go to long range financial planning, and the one piece of information that I would like to share, and then Nora, you can jump in if there's anything else. Our new town administrator, Connor Reed, has brought forth the idea to really like not just do a 5-year capital plan, and in response to discussions in other board meetings and from the residents, to really look at like a 10 to 15 to 20-year capital plan to really get a sense of, because we know we have a lot of needs. How do we prioritize those needs? We need to figure out what all those needs are and have a starting point. So I believe he's looking into bringing on a consultant to help us with that effort. I'm pretty excited about that because I think
That's great.
that conversation is really important. Nora, did I forget anything from that discussion?
No, I think that's it.
Awesome. So that we'll have more news at a later date, but I'm very excited that that is moving forward. Any other agency or committee updates? All right, next agenda item would be miscellaneous updates, general miscellaneous updates and administrative items. Staff, do you have anything for, oh, hello.
Yes. So 3 things. One, we talked about going to the police station to sign the EIDR and special permit regulations. There's also an A&R plan there for 509 High Street. So if you haven't already signed it, please stop by the police station to sign those 3 documents. And if you're the last one to sign them all, just let me or Amanda know so we can go pick it up. Then town election is coming up. That's next Tuesday. Keep that in mind. And then members should be prepared to attend the town meeting on May 4th. All planning board members are expected to attend. That's a general meeting of the planning board. This says members are reminded to arrive at least 10 minutes and sit at the planning board table at the front of the gym. I believe we're actually in the auditorium, not the gym. So I will double check on that. But if we're in the auditorium, the plan is usually to have a table up front that the planning board members sit at. And then the other item I want to bring to your attention, at the May 19th meeting, you'll be looking to select officers, but you'll also be selecting representatives for the various committees that we then send to the select board to make the official appointments. So what I have here is a list of the current committee assignments. The only one I'm not quite sure about is the TRIC, Three Rivers Interlocal Council, where Elijah was the prior member and Sean was the alternate. And I just can't remember if we replaced Sean with Michael or with Phil. So what I'd like you to do is just take a look at this list and give some thought over the next month to what positions you are interested in volunteering for, so that when we take this up on the 19th, you'll
Nora,
have an idea.
I see a real absence of 2 names, and they begin with Maureen and Tim. Not to say, but I
Maureen is
see
right here,
a
Westwood
real absence
Environmental
of
Action.
a couple of. Oh, okay.
And the Board of
Yeah.
Health.
Yep. Okay. You're
Board
right.
of-
You're right.
I'll keep
Maybe only one
playing.
person.
I'll
I
keep
think-
playing the baby card, Phil.
There's only, listen, I got 4 kids and they're all grown, but there's
All
only
right,
so
it's
long
10
that works.
o'clock.
We can make you an
Okay, 10
alternate for
o'clock.
something, Tim.
Sounds good.
And
Tim, you
for
have to have one.
Yeah, I
One.
can squeeze one in.
one, that's right. Nora, what time for some of our board members who will need to be re-sworn in? What time? I mean, not that they have to, but I like seeing all you sworn in. What time do they usually do that? Is that ahead of the meeting starting?
Yes, it's right before the meeting begins.
Okay.
Yes, that's
Okay.
the first point of business. Right before it begins, there's the John J. Cronin Award and the swearing in of members.
Great. Okay, so a little bit before 6, that usually happens, right?
Yes.
Okay. All right. Then are any other miscellaneous or administrative updates?
Yeah, one more thing. So IQM, we officially lose it at the end of June. At the end of June. And that means we have 3 more meetings with it. So you are going to be getting invitations from Diligent soon. Please set up your accounts because we want you guys to start practicing with it before we roll it out to the public. And then, my hope is we have it out to the public by the second to last meeting. And then the last one is our work out the rest of the kinks. We're still requesting additional features and trying to work out stuff, but at this point, we don't have a choice but to start the transition. So please set up your account as soon as you get that.
Thank you. Jess.
Will I get an account too?
You
Yes,
will. So
An invitation.
I'm playing with the minutes side of things. I was playing with it today because there's some live meeting features, but we'll take it step by step.
Thank you.
Great. Thank you. Any other administrative or miscellaneous updates? I'm not seeing it. Our final agenda item is upcoming meetings. We have upcoming board meetings on May 19th, 2026, June 2nd, 2026, and June 23rd, 2026. As Nora mentioned, we also have our town election on April 28th, 2026, and annual town meeting, May 4th, 2026. If there are no other agenda items, I would entertain a motion to adjourn.
Adjourn.
Second,
Hello.
on my mute.
No,
No,
you're
no,
good, Maureen. You
you're
were good.
I have a motion and a second. Any further discussion on adjournment? Seeing none, I'll take roll call. Phil,
Aye.
Tim,
I
Maureen,
Aye.
I vote aye as well. Motion carries. We are adjourned. And it's only 10:02. We made it.
Wow.